Good, afternoon, right? It's afternoon.
Sure is.
Sure is. On December 18th, 2025, we are here with our continuing coverage of the Richard Allen case. As you all know, the brief dropped. Richard Allen's appellate brief hit the dockets today. Sleuthie was the first one to get it to us. I was panicking in the morning. Osbrook was like, there's some weird thing on the docket, and I don't know what it is. I'm like, oh, God. But Sleuthie calmed my nerves. She's like, got it. I'm like, oh, thank God. And then she emailed it to us because she's amazing. So
I was minutes away. I just figured out where it was, and Bob screamed.
I had zero doubt that you would have.
I got it already. I was like, all right, thank you, Sleuthie. She's
She's
a legend.
Great. So what we're gonna do, so this is gonna be a process, right? This is not going to be a one live stream event. This is going to be something that we're going to go through multiple live streams. We're going to incorporate Andy Baldwin. I don't know if that'll be today or tomorrow. We're going to bring back Osbrook. I'm hoping to get Allie and Andrea together where they can collab on it. So we're looking to do a lot of content on it. We want to be able to analyze it fully. This is going to be our first blush impressions of the thing. We're going to go through it. I'm going to, Allie's going to pretty much steer the ship. I think we decided that I do want to go through the statement of facts, which is lengthy. And she definitely wants to at least touch upon some of the issues, if not go into kind of full-blown analysis on them.
No, not yet. Not if we're going to go through the statement of facts. And for those of you yesterday we did a primer on appellate.
No.
Okay.
Yeah, forget it.
But so we're not going to go through too much about what to expect in appeals and all of that because we did that yesterday. But one thing I did want to note, because we're going to go over in detail the statement of facts. The statement of facts, it is part of the rules, cannot contain argument. So when we get to that and you're hearing it and you're like, why are they just saying this so a matter of fact without explaining or saying how it was wrong, that something was wrong or something was misleading? They're not supposed to be putting any arguments in their statement of facts. Their statement of facts are the things that are important, the facts that go to the issues that are raised, the facts the court needs to know. So when we're hearing that, don't be like, why did they just say it like that?
Yeah. And another thing that I just want to kind of refresh everybody's recollection as to the fact that, remember, appeals are limited to what's in the record. So, we realize that a lot of our viewers are deep divers into this case that have been looking at every single angle of this case, that, the things that were discovered when certain evidence was released after the trial, and people are finding things, new things that weren't brought up at trial. So when we're going through the statement of facts, don't be asking yourself, well, why the hell aren't they bringing this up? Why aren't they bringing that up? Why aren't they bringing up? So all those things, that's post conviction. That's post conviction world. That's not direct appeal world. So, I caught myself doing it, but and remember, they're limited to 24,000 words. And if you know anything about this case, 24,000 words ain't even close to what you need in order to cover every issue that's involved with this proceeding. I mean, it was a thing, so in terms of what we're going to look at, I think that, we'll try to, and we're going to evaluate it, with intellectual honesty. I mean, if there's things that we would have liked to have seen in here in lieu of something else, because that's what it's always going to be. If we're like, oh, we wish they would have done this, well, then we're going to have to say, okay, well, what are they pulling out? What shouldn't they have put in order to have added that in? Because I mean, that 24,000 is like, can't be one word over.
But I am sure that those of you that know this case best are going to say, wait a minute, what about this fact? And that'll be a fact that actually was in the record. Whether or not it was introduced at trial, it was introduced at the trial level.
Yeah.
Is the entire record. So I think what we should do, babe, is just give them the issues and then go to the statement of facts like you wanted to do. And then we'll save the deep dive on the law and the issues presented for our next live, or maybe our live with Michael, or we see how it goes. I've got it up, or do you want to?
Yeah, you could pull it up, and then I'm gonna probably read along. I'll have it so I can see it. So we'll split the reading. I mean, obviously, it's a lot of reading.
It's a lot of reading.
And I am most certainly fighting a pretty hellish cold.
Oh no!
It started yesterday. What do you mean? Oh no!
That sounds like I'm doing a lot of reading.
I mean, I'll power through. Like, I'm not gonna, but if I start sounding like shit, you're gonna have to tap in. So,
all right, let's share this.
Oh, and you know what? I'm gonna turn the ads off. I think I set it for the ads. People keep telling me, like, YouTube was supposed to have like fixed the ads so that they were like properly placed and weren't like constant. And like, people keep telling me in chat that the
what
ads
is happening here?
Overbearing. What do you got?
I don't know. How do I stop sharing?
What are you sharing? I'm not on the.
Oh, you don't see it?
No, I'm in YouTube.
Oh, I don't know why it's not giving me my why it's bringing up like a weird
version.
It's bringing up like my search history in Acrobat. I don't know why. Because I was trying to search.
Can you exit off
the transcript? I'm trying. Weird. All right, let's just see if this will. Oh, I know what happened. I think it's because I made that so big that it went.
Let's see here.
All right, I closed. Now I couldn't close it because I was sharing it.
Oh.
Oddly enough. All right, let's do this again. Tech wizardry.
Always.
There we go. All right. So what we're just going to start with right now, and just so you see you're not really missing anything, it's just a table of contents, is the summary of the argument. So these are the issues that were raised. And this is where you want to start, babe?
No, you start it. I think Andy's going to jump on with us.
Okay. About what time you think?
Like now.
All right. Amazing.
Sounds like he said he had a light day. I'm going to send him the invite. We'll power through, and when Andy can join, he'll.
Well, then why don't we? Because I kind of like to see. I'd like Andy's opinion of these. I mean, I guess we could. It's short. I mean, we could read them and then we can go over them with Andy when he gets here.
100%. Yeah.
Because, all right. So issue number 1 is the trial court committed reversible error by admitting evidence seized from the unconstitutional search of Allen's home and denying a Franks hearing. All right. So obviously, you guys know this encompasses a lot. Now you have your A and your B tell you, why the defense is saying this happened. So A is the trial court erred by concluding that Detective Liggett did not make false statements or reckless omissions in his affidavit. They go on to say that Detective Liggett omitted and changed key information that undermined his conclusion that Allen was bridge guy. And now in these later sections, they go over it in more detail. But Detective Liggett's omissions and false statements recklessly misled the judge. And that goes to the description of Allen, the description of his car, what the witnesses said, what he said he was wearing versus what Liggett said he was wearing. And again, they get into that in more detail later on. Um, with the admitted and accurate evidence, the affidavit was insufficient to establish probable cause, which is what the defense was trying to establish through their Franks hearing by their Franks memo, and that the error requires reversal. Now, B, at a minimum, Allen is entitled to remand for a Franks hearing. So first they say, hey, court, reverse it. She was wrong and give us a new trial, essentially. And then they're saying, B, alternatively, send it back to the trial court. And yes, that's in front of Judge Gull, and give it that Franks hearing you never gave it. Now,
So let me ask you, how does that work? So say they do that, he's convicted, say that they send it back, they do a full Franks hearing, and by some miracle of God, Gull's like, yeah, you're right. That warrant shouldn't have been issued.
well,
So
then it would be, then
what
there'd be
happens?
a retrial without that evidence in, assuming that they still decide there's probable cause to charge.
So, but like, can you explain it more fully? So if they go down, she rules, okay, that evidence
So
is
they would,
out. I mean, doesn't the appellate, like, can the trial judge vacate the conviction?
well, the court can vacate the conviction and, well, I mean, I guess it depends a certain ways, and I'm not sure what they do in Indiana, but it would be, this has to go down for a Franks hearing, and if it's determined that the evidence wasn't shouldn't have been admitted, that he's entitled to a new trial.
Okay. I mean, but you still have the issue of the conviction. I
I
mean,
think that they would vacate the conviction to,
what I'm assuming is that if, and I don't think this is going to happen, by the way. I don't think that this is going to be relief that's going to be granted by the appellate court. But I'm assuming that what would happen, and correct me if I'm wrong, is that they would flesh that out, right? Like the appellate court, in their opinion, if they said, okay, we're remanding it back down for a Franks hearing. If the judge does this, this is what happens, right? I mean, it seems like they would have to a certain extent.
yeah, but it sometimes it just depends. Sorry. See, in Indiana. So, when they send it back, like for even like a suppression hearing, they are vacating the original conviction. And so the court has to decide the suppression hearing, which could lead to a new trial, or they could dismiss it, right? If it's crucial evidence, and they say, okay, well, now we don't have any probable cause, but it tells them fix the legal error, which means setting aside the prior ruling and potentially vacating the conviction pending the new proceeding. So
Yeah, that's where my whole question is like the mechanics of vacating the conviction. Because if they're remanding it down just for that hearing, then obviously the conviction. So it's kind of a weird circumstance, to be honest with you. It's kind of like a strange thing to ask for, in the sense that, because you're kind of pretending that the conviction doesn't exist to a certain extent. If you're remanding it back down, and it's like I'm having a hard time understanding how that would work. to be honest with you. But let's keep
Well,
on.
so I mean, and they can like retain jurisdiction afterwards. Like we're going to remand it for this hearing, and then
Right.
retain jurisdiction to come back and decide. But basically, when they do that, they're saying there was a flaw here, because they're not going to just remand it because there wasn't a hearing if they decide that without that evidence there was sufficient evidence. You know what I mean? So if they do that, that's them saying, hey, there's an issue here.
Right.
All right, wait, let me get back to the other screen. So 2, the trial court erred by admitting statements Allen made while gravely disabled during his unprecedented pretrial solitary confinement in a maximum security prison. So then they go over the standard of review. They include some additional facts. They argue that the trial court abused its discretion, so that's an evidentiary issue, by refusing to admit the IPAS order/settlement into the suppression hearing. And Bob, remind everybody what that was.
That was essentially a settlement that was entered into, that they tried to get between Indiana and I think it was Richard Allen. Like I'm not 100% on the
No, I think it was I thought there was an
you're right.
older case.
It had nothing, right? It was an over, like it was just legislation but there was language in there that was relevant to Allen in terms
How
of
long you can leave
how
someone
long
in.
they could keep him in there, right? And she refused to allow it in. I mean, it's an issue, I suppose. I don't know. Well, we'll see. We'll see when they get into the argument.
Right. It's hard for us to make. So Bob was reviewing the statement of facts while I was reviewing the law before we came on. Actually hadn't gotten to that issue yet. But once we
I
get
didn't
into
get to any of the issues. Like,
right.
I had to go bring Scarlett Starbucks. She got an A on her social studies final.
Yay.
Kid hits me at like 11 or like 8:30 in the morning. She's like, "Hey, Daddy, guess what?"
Okay, so the here he is.
Awesome.
Almost.
I'll wait till his camera gets on.
All right, so we can pause. I'll tell you guys what's not in here. That is an argument about him being denied his right to counsel, a cumulative argument, which is bizarre to me. Hey, there he is.
What's up?
Usually Thursdays are pretty busy, but I've got a few minutes I can.
Yeah, I started peppering you pretty early. I'm like, what's going on, man? I'm like, don't leave me hanging, dude. Like, where is this thing? Why can't we get it?
Yeah, I got it last night and read it. I was up till 1 or 2 in the morning reading it.
Yeah.
Well, why don't you give us your initial thoughts?
It's incredibly well written. 24,000 words, not even remotely close to give you, what you need to give a full assessment of what happened there. So I think Stacy and Mark had to do and did a great job of what I would say prioritizing the issues. They are big time pros. Yeah. Everybody in the state of Indiana knows that. And so they know what's going to work in terms of matters of importance and what might be able to be left on the editing room floor. For example, there's no mention of Elvis Fields. There's no mention of Kevin Murphy, I don't think, or things like that. But, Elvis Fields would take up, and that whole Rushville crew would take up 5,000 to 10,000 words and to tie all that in together. And my hope is that the appellate judges, their staff, their clerks that actually, I think, do a lot of the work, will take the time to read the Frank's memo in its entirety and all Frank's 1 through 4. And that way they can at least have that background. And I know those were part of the exhibit. So I thought it was incredibly well written. There was efficiency in their use of language. They knew that they only had 24,000 words. So I was very happy with that. There's little things that just made me happy, little things that, as the whole Franks and the Norse paganism, Odinism, it has, I always have felt that there's a lot of people that have never really understood why that was not a joke, why that was not, what do they call that, Satan or devil? There's some
satanic panic.
Satanic, yeah. My wife talks about that. Why it was not satanic panic, and so when you read the words and these really incredible appellate lawyers are actually using that as the lead to the Franks memo, then it makes you feel like, okay, I'm not crazy, because when you're me, you feel gaslit all the time in this case. Like, am I not seeing what everybody else is seeing?
Right.
And so when the Franks memo and the Franks issue was the lead, and that wasn't necessarily the Norse paganism, but that was also, Liggett, flat out lying in a probable cause affidavit. And, you just think, am I missing something? Did this not? And then Judge Gohl, I think in her order, said, no, we didn't find that there were any false statements. Well, I provided you the evidence. I mean, the Franks memo was, it had how many ever footnotes and backed up. Everything was backed up with facts. So for Stacy and Mark to put that all together and see that was really terrific. Just a couple other things real briefly that I thought they did a great job on the Brad Holder alibi. If you haven't read that yet, they really culled CULLED. They really culled Mark and Stacy information from deposition work, from testimony at different hearings, and they put it together so that everybody can understand that it was not an ironclad, alibi. And on top of that, who is Judge Gohl that's a jury's decision anyway, 100%. And so for her to take that, and I think that was her main reason to say, the judge never really put anything in an order that, where you could understand her reasoning. But I think that was something that we had heard during the trial and various hearings, was like, well, he had an alibi. Well, that's what you say. Right. There's Mark and Stacy did a great job of really showing that here's what could have happened. I'm Brad Holder. I'm walking out at 1:30, that's when my shift ended. I'm getting in my car, and then I'm calling a buddy of mine and saying, hey, it's 1:45 p.m. I forgot to clock out. Would you go clock me out, buddy? And the buddy clocked him out. That's a real possibility. That happens, and that could have happened here. But Judge Gohl thought, no, that there was enough there. So I was very pleased with that. And one of the nice, Stacy and Mark are really good at little, like for me, I can be a bit bombastic at times in my writing style, and that's not appropriate with the Court of Appeals. And they do a great job of understatement. Like, for example, when they're talking about how we should get a Franks hearing, they say something, Mark and Stacy said something in one of the paragraphs, like, they should get a Franks hearing. And it's interesting to note that the Fort Wayne lawyers that replaced us, Scrimmins and Labrado, Judge Gohl offered them a Franks hearing. And then the next sentence was something very biting, like, who Richard Allen's attorneys were should not prevent him from having constitutional rights. So there was things like that I thought were terrific. But all in all, I'm pleased. And when you read it, the last thing I'll say is, I don't understand. My wife was reading it, and she said, how in the world do you not allow the third-party suspect stuff in, knowing all the things that you see? And also, why wasn't the Franks memo, why wasn't the Franks issue granted? Why weren't we given a hearing? How can that just be the case? And you feel like gaslit in a way, like, if this doesn't work out, I just don't know what I'm gonna. I don't know.
It's like you said, though, man. It's 24,000 words. And imagine if they hadn't been given the leeway to put the additional 10,000 in there. Like, every word is precious in an appellate brief. Like, you you use a lot of adjectives when you write. You're like
You said
for this,
bombastic.
they have to cut down, they have to trim all the fat on this thing. They have to kind of keep it as tight as they can. But like you said, like the biggest takeaway was so critical that not only the Franks memo is a part of the record, but also the exhibits. And we just have to hope against all hope that somebody, whether it's like you said, whether it's a law clerk, whether it's one of the 3 judges on the panel, somebody reads it, because that context is so important. Like to me, like I wasn't aware that they didn't mention Elvis Fields. Like to me, Elvis Fields is, when you're talking about
he confessed in my mind.
he did confess. I mean, there's no two ways about it. I mean, the man said that he spit on Abby, that he was at the scene. It's like, you've got this dichotomy of these Allen confessions, and you've got this guy who's walking back to Kevin Murphy, who we all know, if you know the guy, who is salt of the earth and is genuine and honest as a cop that exists on the planet. I mean, that's just who that guy is. And he has no reason to lie about anything that happened that day. And when that guy comes back and says that to him, I mean, what is another takeaway from it?
Well, especially Bob, when you, this is what's always gotten me. What I'm about to say to me is like the linchpin that causes me to believe that the evidence should have allowed. I'm not going to say who did or didn't do anything, but somebody has got to tell me why Elvis Fields in Rushville, Indiana, 125 miles away, knows about the existence of Brad Holder on the planet Earth. And those 2 facts, and even Judge Gall had to admit in the trial when we were trying to get her to I believe the state opened the door to allowing us to talk about the Norse paganism component. But even Judge Gall, when I stood up at the end of one of the days of trial and said, "Hey, what are you going to do about them opening up the door?" I had filed 2 motions that I reread those recently, and they're really, I mean, I'm very critical of myself, but those were really well written. They were really, they encapsulated a lot of information from the trial that showed that they had opened the door and that we should have been allowed to talk about the Norse pagan stuff. But even when I made that request, Judge Gall said, "Well, all you've proven is that Elvis Fields basically knew the people in Rushville knew the people up in Delphi area, and that's all that you proved." And I'm like, well, that's a pretty big deal, actually. When one of the guys has confessed and the other guy has all these runes and things on his Facebook page up there, Brad Holder. So
yeah. And when you think about Elvis Fields, 125 miles away in Rushville, and who a guy that we all know to be developmentally disabled to some extent, like he's not a guy, like how does he know anything about the details of this crime? And I'm talking about that there's even 2 girls. Like, I mean, like, where is this guy getting that information? Like there's nothing about the Elvis Fields thing.
And that's okay. Yeah, that it's okay that it's not in the brief. I'm not going to be critical of anything. My wife said this to me. You're going to be like, where is that? And where is that? And I said, you're actually wrong on that. I already know that these 2 are going to put out an unbelievable product. And there's things that just have to hit the editing room floor. There just is. And that would have taken way too much time. And I thought the efficiency of talking about the Holder piece was very, very well done. It's only done in 4 or 5 pages, kind of near the end, in terms of them kind of putting it all together. And I thought it was well done. And it's just hard for me to believe that you can read that and say, yeah, this guy got a fair trial. He did. He didn't.
Right.
Right.
I mean, which is the bottom line here.
I've got one question, though. I know you don't want to be critical, but I'm going to pull up this second issue here about the lies that Liggett told in the affidavit in order to get the search warrant, which is, part of needing the Franks hearing. And they say that he misled the court that Allen's car was parked at the old CPS lot during the time of the kidnapping. It goes on to describe the cars, but then it says that Liggett told the court that Allen parked his black 2016 Ford Focus at the old CPS building, but omitted that Blair said the car she saw during the during the time frame was not black and had sharp angles like the sketch below. So I call up to Bob. I'm reading this. I'm like, wait a minute. Wasn't this the person who said the car looked exactly like my father's, like somebody's old car? And like,
Well, Mercury,
Yeah, like a Mercury Comet.
Yeah.
Which is
so
looks nothing like that car.
Right.
And I don't know, maybe maybe that's something that they raise again later, but I thought, wait a minute, it was more than just this little sketch with sharp edges. She specifically described the type of car that it looked like, and I thought that needed to be in there.
Yeah, I mean, I think when you got 24,000 words, you got to figure out what's important there, and
Always,
you know, and it's hard to put all that, make that clear too. Like right there, what's important to also note, and I remember asking specifically Liggett in his deposition, and I think some of these are out there. I get emails from people saying, "Hey, this is out there, this isn't out there." They've redacted some pages on some depositions or whatever. And I think this should be out there but Liggett, there was a very kind of important moment during the deposition where I was trying to pin him in. So you're saying Richard Allen's car was at the CPS lot at what 1:30? Yes. At 1:45, Richard Allen's car was there. Yes. 2 o'clock. Yes. All the way to 4 o'clock. And that way everybody understood that when Betsy Blair drove by the CPS lot and saw a vehicle there, that was supposed to be Richard Allen's car for the state's theory to work. And so when Betsy Blair describes what you said, Allison, as a vehicle that looked like a 1960s Boxster, a very angular car that looked like her dad's Mercury, what was it?
Comet.
Yep. That was not Richard Allen's car. And the most important thing that we're omitting, and which Stacy and Mark did a great job of showing, is that was not given to Judge Diener at the time, who was making this important decision about whether allowing police to go into a citizen's house. And that I like the way that there's a case out there. We used it in the Franks memo, and Stacy and Mark used it in this case. And it's very simple. Here's kind of the test. If you think if you omitted something that you think a judge would have wanted to see, or would have been important for a judge to see, or you provided inaccurate, incorrect, deceptive information that the judge should have known, then that's where there's a problem. And when you tell the judge in this case, as Tony Liggett, 2 or 3 weeks from his election, when you draft this document that it was 2 to 3 weeks out from an election, and you're looking to arrest somebody, and what you do is you say, Richard Allen's car was there at the CPS station and Betsy Blair saw it, but you don't say, well, no, Betsy Blair didn't describe Richard Allen's car. She described a completely different car, in not only in the way that it looked, but even the color. Betsy Blair specifically said the car I saw was not black.
Right.
And Richard Carr was black. And that's just deception. I mean, that's just flat out deception. And my goodness, if we can just allow police to get away with that type of deception in order for them to get into somebody's house, we're in real trouble. I mean, that should not be allowed. And that was just one thing, the way
the important part of it is that because you have to remember, this is attacking the search warrant on the house, which means that they don't have Richard Allen's gun at that point. So everything that we're talking about in terms of determining if you pull out what Liggett lied about or omitted, and you look at it on its face, is there enough probable cause? And there's just no way in hell. No. There's like literally nothing. I mean, they didn't even go so far as to go to the girls who claim that they saw a bridge guy and ask, hey, we're going to show you a 6-pack. Okay. Do you see the person that you saw on the bridge? I mean, there's no actual identification of the person that they saw.
Ever.
There's literally no evidence other than the fact that Richard Allen volunteered the information that he was out on the bridge at some point in time from either early afternoon to mid-afternoon. And that's it. That is, so we're talking about mere presence.
Oh, he had a blue coat, Bob.
Or black. Or black. Or, we don't even know if he was driving the Focus, is the reality.
Yeah.
He could have been in the Ford 500.
Well,
I mean,
somebody on that topic, I got an email. I think it was from Professor Osbrook that showed like the wheel well of there was a circle around the wheel well of the image that was on the Hoosier Harvest store camera that they claim was Richard Allen's, and then
yeah.
they showed the same wheel well circled
Yeah, that was our
Richard's
very
actual
own.
car, and it was not the same. And that's where you, as a trial lawyer, you're like, how did how?
That was our very own Yellow Jacket.
Whoever did that.
Yeah,
That
that
if this
too.
gets reversed, that's going to be something that I already I saw that, and I'm like, how did we not see that? And all those things that you do as trial lawyers. But I believe we're going to get another chance here. If it's not me, that's I don't know whether I'll be allowed to be back on or whatever. But if I do believe, and you don't want to jinx it, and you don't want to certainly have the Court of Appeals clerks going to the judges and saying, "Oh, he says that this is a no-brainer" or whatever. I just want fairness, man. I mean, it's all that I've ever wanted, and I think I'm just trying to be. This is my opinion. I'm looking at it as a person that was involved in it and knows what these cops did. And as it relates to the issue one, the Franks memo, they lied to a judge. They lied to a judge, and Judge Gull never let us go into court and talk about that. There was never any discussion about that. I mean, there are many judges that Bob and Allie, you have been with, that would say, let's go into chambers. Hey, prosecutor, you got a problem here.
Right.
I need to know what the hell is going on here. And there are things that are flat out inaccurate. They look like it's deception or a lie. And we need to have a hearing on that. And that could have happened over and over and over again during the course of our representation of Richard Allen, whether it's the Purdue professor fiasco, or the Reese Davis stuff that happened after the sentencing. Nick McClellan just flat out lied to me in an email, and nobody gives a damn about that. And it's very frustrating. And again, a judge would have in many courts would have said, I don't know what happened here, but somebody ain't telling the truth. And that also about Tobe Lesenby and why, Tobe Lesenby, when he said the reason we didn't bring Robert Bastin over, a defense witness that was going to talk about Richard. This is one of those things that gets me so irate, and it's not in the brief, by the way. None of this is in the brief, and that's okay. That would have never had that. It's not. The place is not for this brief, for this Robert Bastin situation. Yet it's another example of Judge Gall, says, I never told Sheriff Lesenby not to bring Robert Bastin to this important hearing. He's a defense witness. He witnessed Richard Allen mistreated, and we want to bring Robert Bastin, we the defense, to the hearing. And we're told by Tobe Lesenby in a writing that Judge Gold told us we didn't have to bring him if he didn't want to come. And then Judge Gold tells us about a year later, well, I never said that to Tobe Lesenby. They didn't bring him on.
That.
So somebody's lying there. And this is important as it relates to the Franks memo, because one of the things you'll see when you read the brief, getting back to the brief, is we have to, in some situations, we have to prove that there was some shenanigans going on with the police. And that's an example of shenanigans going on with the police. Either you believe Judge Gull or you believe Tobe Lesenby. And I think most people will believe Judge Gull, rightly or wrongly. And that means that Tobe Lesenby lied. Well, if he lied about that, what else did he and the other law enforcement lie about? And if we get back to a Franks hearing, that's the type of stuff that will come out at the Franks hearing, because all of that shenanigans, all of it, Purdue professor,
yes,
Reese Davis,
all of it,
all the missing, all the things, the lies, everything that comes out because that's part of a Franks hearing.
Yep.
And Bob's always made the point that, like, people are like, well, this doesn't have to do with the warrant. It's not a lie for the warrant, but you have a burden to show that they were doing this intentionally. And Bob's always saying, that's why Andy and the lawyers are explaining all these other situations they have been caught lying, all these other situations they have overstepped, so that it impeaches their credibility with the court and makes it more likely that what you're arguing was an intentional act, an intentional misleading, whatever the case may be. But the judge just never, as we all know, and you just said, refused to look at or consider any of that.
And
I
maybe,
just hope to God they somebody reads the Frank's memo. I mean, there's just so much there. Like, Andy, I cannot tell you, like when they released all the calls and I got to hear them again, because you know how it is in trial. Like, they're playing Rick's confessions, and I'm listening as diligently as I can, trying to take note, whatever. But when I hear, and I'm hearkening back in my mind to the Frank's memo, and I hear Richard Allen just flat out state in one of his things when he says, I'm trying to figure out why they're trying to hang this on me. And the only thing that I can think of is that there was this election, the sheriff's election. Was like, for them to read the Frank's memo and then see that Richard Allen put that together himself.
Yeah.
Prior to, like while he's developing psychosis, when he's like on the verge of becoming psychotic, and he's got the last semblance of being lucid, he's trying to figure out, like, why me, like why me.
Yeah.
And he says that, and then when you see it in the Frank's memo, and then you hear Richard Allen saying the exact same thing, because I don't even know. I mean, when you wrote the Franks, had you listened to all the calls yet?
Oh, we didn't know anything about these calls.
That's what I mean, man.
We didn't get any of that stuff, most of it. I mean, I don't think even the April 3rd stuff we didn't get. And I thought Stacy and Mark did a great job on that part, really, because I think that's kind of, if I'm trying to anticipate the AG, what they're going to try to do is, this is harmless error because of the confessions, I put that in air quotes. And I thought Mark and Stacy did it. I don't remember which one of them was in charge of that, but they did a really great job on that. And one of those sections that I thought was really, really terrific, and I would just not have thought to do, but that was the section in the brief where they're talking about, hey, there was only one-sided stuff coming out. The confession, the bad confession stuff, if you want to call it that, was not the defense was once again not allowed to bring in their own evidence to show that the confessions weren't. There's another side to that, and so, for example, kind of like what you were just talking about, Bob, on April the 3rd, the very first phone call that Rick made was to his stepfather, and he's basically saying, "I'm going out of my mind."
Yeah.
And I don't know what's going on. And I think he even said something like, if Kathy just needs to move on, then, I may just kind of do this and say, I might do something stupid or say something stupid. The transcript is what it is, and you'll read it. But Mark and Stacy, did a really great job of showing that the jury did not get a full picture. And that's really, if I could say, what is like the takeaway from the entire brief, that is the takeaway from the entire brief, is the jury did not get the full picture.
Right.
They did not. They were not allowed to have the full picture.
Right.
And Richard did not get a fair trial because of it.
Yeah, 100%. I mean, Judge Gull crafted this trial in such a way that everything was seen in a certain way. You know what I mean? It's like you guys were cut off at the knees in terms of being able to put on any defense. I mean, you guys had to lean into reasonable doubt because that's what you were left with, so you had to try to, poke the holes in their theory. And, for them not to have been privy to that. And that's what I hope ultimately that the appellate court's going to have to say, look, because it's like you have to think you've got these three judges that are going to be on the panel. They're going to have some knowledge of this case. It's one of the biggest cases in Indiana history. You're talking about the death of two beautiful little girls. I mean, no appellate court judge is going to be, just eager to vacate a conviction, remand it back to trial because they understand what comes along with that. But at the same time, like, the Constitution has to prevail here.
Yes.
The right to a fair trial has to prevail. I mean, the man deserves to have a fair trial. Let's let it all get out there and let a jury decide based on all the evidence that we know exists. And man, like, I know I keep saying it during this live, but your point that God, I hope somebody reads that Frank's memo, like, because we know Gull didn't.
Yeah.
We just know that she didn't. Like
all four of them, but the first one especially.
especially the
yeah.
first one.
Yeah.
You know, I mean, the other three were like you begging her, hey, you know, Judge Gull, like I'm not saying you didn't read it, but in case you didn't, please read it for the love of God. As a judge,
Yeah.
please just read this. It's important for you to know the information.
It's really tricky waters that we were in because, you know, you don't want to be accusatory and say, I don't believe that you read this. Would you please? I mean, we're human beings here. Rick Allen deserves for you to read it and review everything and listen to the audio and the video and consider the Purdue professor situation, which was going on at the time and has never been explained. But I also wanted to say something else that was involved in the brief that I thought was great. So all of this stuff that we weren't able to bring to the jury, to present to the jury, the judge withheld us from putting forward so much evidence. Yet, when we caught the state of Indiana completely 100% flat-footed with Stacey Eldridge and the 544 in headphones in and 1032 headphones out. And for those who may not know what's going on there, Richard Allen, according to the state's theory of the case, Richard Allen left. It's the most ridiculous story. Okay, that in 17 minutes, Richard Allen, because he was freaked out, Richard Allen took girls across the creek, did all these things, left a pristine crime scene. And even though he was freaked out, he still had time to put clothes on one and then arrange sticks, clean up the scene, and then still stuck around for a while, even though he was freaked out. So because in 17 minutes, it's still got an hour to go before he's seen by Sarah Carbop on the 300 North. None of that makes sense. None of it works, but we'll go with it. Okay. Right. And so, except there was a couple problems with the phone that was found under Libby's body. And there's two big problems. One is tied into a 4:33 a.m. series of SMS messages that matriculated on to the phone, which suggests that in very strong terms, in my opinion, that the phone was not there at 4:33 a.m. The phone was connected to the tower, is a good way to say it, at sometime maybe at 4:33 a.m. when the phone came back into the area. It's always been our contention the phone was not there. And here's another big time thing that happened that shows the phone was not there. And that is that at 5:44 p.m., somebody put headphones into that phone. We know that through a Celebrite extraction, which details, it's like a log of everything that happened on that phone. It's in the inner workings, in the inner bowels of the phone. You extract that out. And the state police in Indiana were nice guy, Chris Cecil, nice guy. He was the detective in charge of the phone extraction, but he was really out of his depth, big time out of his depth. And since the FBI had been kicked off, Chris Cecil's doing the best that he can. And what Chris Cecil did not find is what our expert, Stacey Eldridge, found. You've had her on the show, I think.
Yes.
And Stacey found that somebody had plugged the headphones in at 5:44 and then taken them out at 10:32. And right before they put the headphones in, some type of call came in. And so the thought being that they wanted to shut down the phone wherever it was. Maybe they were still in the woods at a different place. Maybe they were somewhere that by then the word's out on the street that they're looking for these girls and they don't need any attention drawn to them. But at some point in time, right after a phone would have been ringing, and it was a call that came in, they put in the headphones at 5:44, and then a few hours later, they took them out at 10:32. And we know that's not Richard Allen. How do we know that? Well, we know that because the Jerry Holman, we pinned him in his second deposition where Jerry Holman said, yeah, Richard Allen never came back to the scene. Well, if the phone, you got to remember, this is what's important here to remember is the state's theory is that the phone is under Libby's body from 2:32 p.m. until it's found at 11:30 the next day, roughly. Okay. Yet the phone, the pinging problem, that's the 4:33 a.m. that I talked about a second ago, and the phone in and phone out. Okay. That's the big setup for this. We're not allowed to put anything in. We, the defense, third party suspect, all that stuff. But here's what the state was allowed to bring in. When they got caught with their pants down big time, like they had no idea that Stacey Eldridge was going to come in there and say the headphones in, headphones out. That means that there's a human being with human hands that went to that phone and plugged something in and took it out, wherever the phone was, even if it's at the scene, which I don't think there's any reason to think that it was, but even if it was, that wasn't Richard Allen that did that. That was somebody else that did that. And so how did the state of Indiana overcome that? Well, they didn't. And shockingly, the jury allowed a pass on this somehow. But here's what the state did. On a break, in the brief, they say it was during the trial, but it was actually even more specific that it was on a break at trial. Is this it?
Yeah.
So, yeah. In response to Eldridge's testimony, the state asked Cecil whether water damage could be responsible for Eldridge's findings. Over a hearsay objection, I was worried that at that moment in time, when I was reflecting back, Bob and Allie, I was like, did we object to that?
Yeah.
Like, I'm sure that we did, but.
And I think I asked Bob and he wasn't sure either because, everything's happened so fast.
So I was super happy to see this, but this is what we're not allowed to bring anything in. But Chris Cecil got up on the stand after a 15-minute break. You could just imagine these guys huddled around in an office like, oh crap, we just got this, our timeline is completely blown. There's no way that we should be able to win this case now. What are we going to do? Well, let's Google it. Oh, sometimes dirt and water causes, there's some subreddit chat group or something. And there it is. Over a hearsay objection, Cecil testified that he Googled it and found some unspecified, non-peer reviewed troubleshooting forums reporting that this message that it was headphones in, headphones out, could be caused by water or dirt. Right. Okay. And more to come on that, by the way, but in the future. But at this point in time, let that settle in. We're not allowed to put in all of this stuff. And here we are at trial. This is what a normal judge does in a normal situation. We'll go off record. Mr. McClelland, are you insane?
Right.
Do you really expect me to allow a Google search to come in to this jury? And this is how unfair Judge Gull was to the defense, frankly. It was like, that should have been a no-brainer. I don't know any judge. I don't know one single judge that would allow that evidence in under those circumstances without finding out such maybe quasi-important information like, well, where is this information come from? And who's the person that made this information? And this is what's called, they call it totem pole hearsay. And
yeah, they did.
Which means that it's got several layers of hearsay in it, and yet it was allowed in, and that gave the jury all that they needed was some justification. If we could not point the finger at anybody else, Judge Gull wouldn't let us do that. And now we had this big problem that we exposed right near the end of trial, and we felt that's why we always felt good. When we were feeling the worst, Jennifer Auger and Brad and I'd always say, headphones in, headphones out, headphones in, headphones out. We're going to be fine. When that hits, their timeline is blown. Yeah. And then the judge just allowed that. And so it's so great that Stacy and Mark put that into the brief, that made the highlight reel for the brief.
So didn't you guys, and I'm asking only because I don't remember, there was a motion to recuse Judge Gull, correct?
Mm-hmm. No, there wasn't one motion.
Right.
There was like 3 motions to have her recused.
And is that an issue raised in the brief?
No, it isn't. And I understand it. I mean, it's sadly unlikely that from what I've been told that would ever be something that would be granted. And again, you have this precious real estate to work with. I think that is a part of the record, and maybe, one of the clerks will stumble upon it and read it and be like, holy cow,
Which are you speaking about there?
What's that?
That the clerks might, I missed it. They might stumble across what?
Well, I think every single pleading, hearing, motion, memorandum that was filed is available to the appellate clerks and to the appellate judges. And so, what you hope is you get like a super interested appellate clerk that just is going through everything and like, I'm amazed at what's going on here. I want to dig in even deeper beyond even what's argued in the motion, just for some context. And there's nothing wrong with them doing that. In fact, I think it should be encouraged, especially knowing that they're limited in how many words they can have.
Yeah,
I wonder if
and
they could have asked for more words. Why didn't they just ask for, I mean, I've asked for,
can
you
we
know,
have a million words? Because that's about
Those
what they needed.
well, those guys know. Stacy and Mark know where to walk up to. I've always heard this about. I mean, I know Stacy pretty well. She lives, her office is near mine, and I've known Mark. Mark represented me, and I never properly thanked him. I was thinking this the other day, for representing me when in front of the Supreme Court. But those guys know, Stacy and Mark, where to walk up to that line. And do I ask for 100,000 words? They would know. And I don't think I don't want to upset this jury, this group of appellate judges. To the extent that that matters, I think that they probably did exactly what should have been done, and they had.
I mean, it was a two-pronged problem, Andy. It wasn't just the words; it was they had a time limit. You know what I mean? It's like we knew going in when they asked for the additional 10 days. That was it. That was the drop dead deadline. So,
Yeah.
to even had they been given another 30,000 words, I mean, all that's doing is just creating more time pressure in which, because like you said, look, we have to have all the faith in the world. We all know, anybody that knows anything about Indiana appellate law, that Stacy and Mark are as good as you can get. We have to just trust that in terms of when they called the issues that they said, all right, these are the ones that we have to have in here because we believe they are the strongest issues. Now, I mean, if we get Osbrook on, Osbrook's going to be saying chronic, man. Chronic is a thing that should have been in there, and I'm not going to argue with Michael. On the other hand, I'm thrilled that I saw that they included the motion to correct errors. Should not have been denied, because the work that was done on that, in terms of the things that were uncovered in that thing.
Yeah. Thank you, Michael. Yeah.
Yeah. I mean, Osbrook and everybody that was helping him did an amazing job with that thing. And I'm thankful that it's a part of the record. And I'm thankful that it's an issue that has been preserved at this point because they brought it up in this direct appeal. So, I mean, you never know what a court's going to do. But to me, like, to go back to Judge Gull and how she ran this thing, and we're all kind of like, yeah, it's a shame that we couldn't get her clear bias articulated in the form of, the brief and get it in there as an issue, because there's no doubt that this woman was biased. I mean, from beginning to end, that bias was evident, and it started before she even booted you guys off, and she can frame it however, before you guys withdrew. The reality is that we need one of these appellate law clerks and or one of the judges, when they're looking at her orders, her court orders in a double homicide case that is probably, as I've said before, and as everyone knows, one of the highest profile cases to ever hit a courtroom in Indiana. For her to repeatedly deny hearing after hearing after hearing, and then not only deny without hearing, but give no basis in the law as to why she made that decision. Like, I would have to think an appellate court judge could be like, what is going on with this? Like, I've never seen anything like it. Like, just her docket and her court orders alone should put them on high alert that something is off about this case. For me, when I first was starting to look at this case, the first thing that caught my attention, Andy, was the fact that they had sealed the probable cause affidavit. I'm like,
that's because they knew that they know that there's multiple people involved, and they thought Rick Allen was one of, if they really ever believed that he did it, they knew that there was multiple people involved. At that point in time, they thought Tony Klein was involved, and that they were going to put those things together. That's what they thought at the time. I know that for a fact from watching the redacted, the unredacted version of Richard Allen's October 13th interview. That was all about Tony Klein, and it never worked out for them. And so when that, and if you read that initial hearing that I was at, I think it's October 22nd, 2022. Or November 22nd. It's very clear that the reason they gave, whether, either you're telling the truth, Nick, or you're not, we think there's other people out there in this. We don't want to give them information from the probable cause affidavit. So give us some more time. And then, of course, they do, Stacey and Mark, in the case itself, in the brief, they do a great job of talking about one person versus two or more people. And that's a super important aspect of, there was multiple people involved in this crime. Everybody knows it. Anybody with half a brain knows that.
Yep.
But the police had to say it was Richard Allen acting alone. That's not what they believed in November of 2022.
Right. And you know, that's not what they believed because of how they charged him initially. When they charged him with felony murder, which they're like, okay, all we have to do is show that he's the dude who abducted the girls. How they died isn't our problem, because as long as we can show that they died as a result of his kidnapping the girls, you know what I mean? Like, that was a huge tell, you know, and then it's also a huge tell for any defense attorney when they're going to rely on felony murder that they don't have the evidence.
Big time.
If they had the evidence, they would have gone with just straight up murder right from the get, and they didn't do that. So right away, you know, you're like, wow, you know, because when I read the probable cause affidavit, I'm like, what in the wide world of sports is going on? Like, where's the evidence? You know, because like when you guys were originally going to do the motion, I forget what you call it, to let bail.
The let bail hearing, yeah.
You know,
we should have done.
And I was so excited, and this is before we knew each other. I'm like, oh, I can't wait. I'm like, this is going to be a mini trial. The state's going to have to produce some actual evidence beyond this crap that's in this PTA. And, you know, and we all know how that went. So
should have done that, Bob. That's just one of those errors, you know, but we were waiting. The drips and drabs of evidence that was coming in was frustrating. And, you know, we didn't want to go in and look like, you know, like you walk in to getting ambushed or something. Like, it took Nick McClelland until September 8th to turn over the most important, perhaps, piece of evidence, which was Libby's phone dump. We didn't get that until September the 8th. They were supposed to have given that to us in December. And again, these are the things that Judge Gold didn't care about. Nobody seems to care about. But I'll tell you this from the brief. There's a couple things. One that kind of caught my attention was Nick and Stacey and Mark. Sorry, Mark. You're no Nick McClelland, Mark. Okay, you're an honorable guy, Mark. But they do call Mark and Stacey call McClelland out. And I don't remember exactly what it was done, somewhat subtly, but it's like even McClelland said this, and he knew that it wasn't right. And there's that, and that also causes me to think something that just is irritating, or beyond irritating, it's outright, is when Judge Gall said, okay, I'll calm down here. When we had the hearing, the safekeeping hearing on June 15th, 2023, we did not have the videos of Richard eating his feces, pounding his head against the door. We knew about Odinist guards. We did know some things, but we did not have a lot of the bad information that we saw on video that Brad, Rosie, and had to watch over and over again. And at that time, we didn't know anything. Okay, so when we had the hearing, in her order, I think it was in her order, but if not an order, she said it out loud. But Judge Gold said Richard Allen is getting treated better at Westville than he is at a county jail. And I got to tell you something. It makes me so angry. Judge Gold, you owe Richard Allen an apology, because you've seen those videos now. And you said that without learning or knowing the evidence, without bothering to go. Some judges would go to Westville and find out what's going on. That's how dedicated judges do it. But you said that it's despicable what you said. Yeah, it's despicable, because Richard Allen was mistreated there, and you saw it with your own eyes. And you know what good people do? Good human beings do? They come out and they say, I apologize. I was wrong about that. Richard Allen was not treated at Westville as well as he would have been, or better, in fact, than he would have been. He was treated much, much, much worse.
Yeah, and I mean, the good thing is, Andy, that's part of the record, and it's even worse than that, because during that hearing, Nick McClelland flat out calls Brad a liar.
Yes,
and
the liar himself, the chief liar, the guy that lies without thinking twice. Despicably so, calls Brad Rosie, Honorable Brad Rosie, who's as honest as the day is long. He calls him a liar. Yeah, right.
Yeah, the irony, dripping with irony. Yeah, it's
Well, I'll let you guys get
frustrating.
back to it. You wanted me to come on,
Oh,
and
we love you, man.
I
We
got
love
some
you.
stuff to do, but I think it's great, and I don't want to hear anybody complaining about Stacy and Mark.
No, yeah, no.
They're well, I mean, you can if you want to, but but for me, it's terrific, and I feel great about it, and I think they might be setting some stuff up for a reply brief too. Like,
Yeah.
here's another thing not mentioned is the word. What's the big word from Judge Gull? There's no
Nexus.
I don't believe Nexus was mentioned at all in this brief. And I think it's because Stacy and Mark, for the bigger overarching, that there was not a fair trial here.
Mhm.
And maybe if I'm the state, I'm guessing they're going to come back and say, well, there was no Nexus. And then you can really pile on when that happens. Like, you're telling me there's no Nexus with all this stuff.
Right.
So I think there might be some strategy even involved at the appellate. We do appeals in our firm, but we're mainly trial lawyers.
Yep.
But Stacy and Mark, there's strategy involved. I know.
Oh yeah, for sure. I mean, there's definitely going to be a reply brief that's coming, and that's going to come after, because like that's going to be the AG's reply or response is going to be that. Well, Gull was very clear that she heard the evidence during McClelland's motion to bar third party culprits, which she encouraged them to file.
April 28th.
I mean, it's like if they go through the record and they just see the things that she's done. I mean, I'll never forget her saying, "Hey, Nick, trial's getting pretty close. Is there? Do you have the concept of filing a motion to bar third party culprits? You might want to do that." And
Yeah,
dude, like what?
That was basically an Sunday, April 28th email at about 11:30 a.m. when, Judge Gull basically, without exactly saying what you said, Bob, but in so many words said, I'm not going to let that stuff in. All you got to do is file a motion in limine.
Right.
And that was filed within 12 hours. And here we go. We weren't allowed to bring that stuff in. So it's one of the many things that you're getting into those weeds is just it's not proper for an appeal like this. We got to cover the big ticket items. But when this is all said and done and all over, there's a lot of people, whether the appellate process is successful or not, I believe it should be, but there's going to be a lot of people that have a lot to answer for, Jerry Holman being chief among them, who nobody's ever, and journalists, you out there too, you are, you have some explaining to do. Why, even to this very day, I was just, thinking about now this appeal allows for journalists one more time to go out there and start looking at some of this stuff and talking and asking the tough questions that have never been asked. Journalists, if you're out there, that you're being shamed by all these, what I guess they're called internet sleuths out there. They're just putting you traditional journalists to shame.
Yep.
And I think they're going to continue to do that. And and I think this brief gives you journalists another opportunity. And apparently Nick McClelland's out there. I think he had an interview on one of the other podcasts about some things that might have been filed, and it opened up a whole nother Pandora's box of opportunity for journalists out there to ask real journalists to ask tough questions. People that are fair-minded, people that are really neutral. Nick McClelland and Jerry Holman have a lot of questions that need to be answered even to this day. The Purdue professor, all that stuff that I've been talking about, and it's never been asked. And just because the case is over doesn't mean you can't. Journalists, you can still go in there and dig in.
Yeah.
There's some awards out there for people that are willing to do investigative journalism. So get in there and do it.
Yeah. I mean, look, man, like we're all of the mindset, at least all the people that believe in their heart of hearts that Richard's an innocent man. We just have to hope that the judges have the wisdom, to see the truth here, and that they're willing to do the hard thing. It's hard to win a direct appeal. It just is. That's facts. But the reality here is that when you look at it as an honest broker, and you look at how this thing went, I mean, to me, it's as clear cut as there is a case that I've seen in terms of a guy not getting a fair trial. I mean, the man was absolutely railroaded, and you just hope that they're able to see the forest through the trees. And like you said, man, I just they need somebody needs to put eyes and just devour the Franks memo, because it went to the heart of what happened in this case when you guys were barred from bringing that in, and it goes to the heart of why he was denied a fair trial, and everything that they need is in there, everything that they need in order for them to scratch their head and be like, man, what happened here? You know what I'm saying? I mean, like, if you get them to start thinking, like, if they're having a hard time justifying it in their minds, and I'm talking about the appellate court judges when they're looking through it,
Yeah.
and then you're starting to win the battle.
Yeah.
Because at that point they're like, okay. So I mean, look, man, we're all behind Mark and Stacy and Rick in this thing. And
Yeah. Merry Christmas to everybody. And I hope that you diehards out there, by the way, I still don't listen or watch anything. Just not something, it's mentally not a great place to be, because I know that either you're riding high and that's not good mentally, or riding low because people say whatever.
Yeah.
And so people reach in and check in, and I do check out a little bit on, like, I'll Google some stuff, but I'm not out there like learning what's going on out there. But Merry Christmas to all of you that I know are fighting these hard battles and staying passionate. And I've got an idea. I mentioned it on your program last time I was on in August, I think. I've got this idea to get everybody together in whatever facet you are passionate about, whether it's, girls on the bridge at 2 a.m. or Rick's car not matching, or geofencing, or, whatever it is.
all of it. Screams heard in the woods at 2 in the morning. Yeah. That a 911 call is placed, and that's it's like there's so much out there, man.
And different people are passionate, I think, about different things, and they know it because they're passionate. Then they do the deep dive and they do the work. And I think it would be, one of the general big mistakes that we made was not, and I've said this before, I'm not saying anything new, that we did not, it's still hard to know how to do it. Honestly, it's very difficult to know what to look at and what not to look at. But I think if you got everybody together, I just have this idea. I don't know whether it'll come to fruition or not, but I'm talking to a few people to see if they might be able to help out here. Is sometime maybe in the summer, get a hotel conference where there's breakout rooms, and we can all take a bunch of notes, and really whoever the lawyers are that come in, whether it's us or anybody else, we can give them memorandums and just say, hey, you may choose to use this, you may not choose to use this, but here's a lot of stuff that's going to be helpful. And I don't know, there's something really good about that, because sometimes I'm looking at the things that those people out there that are very passionate, that somebody will send me something and I'll be like, holy cow. I mean, I had a lady in England that I've talked to, and she's shown me some stuff that on the at Libby's phone that she got, that she's done a deep dive on and looked at. And I'm like, holy cow, there's something there. And there's people passionate about that.
Oh, dude, Andy, you have no idea, man. Like, yeah, it'll be a think tank, except we're going to call it the crank tank, because like so this isn't just people that are like, hey, I found. So what they do is when they find something, then they follow up and they vet it. You know what I'm like?
Yeah.
This isn't a situation where like, oh, gee, look, this is interesting. This is, oh shit, this is what I found. We're gonna follow up on it. We're gonna vet it, and we're gonna see that it's legitimate. Like it's, yeah. I'm not letting you do anything other than involving them, because I will be on your ass like you wouldn't believe, because it would be. There's just too much out there. Too much has been done. There's just so many people that are so involved behind the scenes with this case that genuinely care.
Well, it sounds like a crazy thing to do, doesn't it? And I think you'd almost have to have Jennifer Auger. I talked to her about it, and she thinks, oh, that's a good idea. But what happens if there's moles sent in? And part of me is like, I don't really care if police want to come in and listen to what's going on here, as long as they're going to be honest and do things the right way. I don't know that I could ever trust that.
We know who's who. We know who's who here.
Yeah,
like,
get some badgers or something.
Yeah, we're like, nah, man. We're like, I know who's who. I know who's who, and I know who does what. So we're in good stead there. If we get a random in there, it's a no go.
We'll see whether that can be a reality. It sounds crazy, I know, but we got a man's life on the line here, and if there's people out there, since the state police didn't do a proper investigation, we know that we're now going to rely on the people. We the people. I think it's not. I don't think it's crazy at all to do that.
I mean, you have to look at it, Andy. Like when Northwestern University decided to, that their journalism students decided to really dig into a case. This is that. It's the equivalent. Don't be thrown off because people are on the internet. I don't give a fuck where they're at. Pardon my French. Mm-hmm. These are brilliant people. These are passionate people, and these are people that truly believe in their heart of hearts that Richard Allen's an innocent man, and they do the work, man. Like these are all highly educated people. These you know what I'm saying? Like all of that. Like I don't care what it looks like to the outside.
Well, you know them, but the stuff that I have seen that people have sent me is like, wow, that's brilliant. And so I'm not, and maybe Bob, you can help organize it, or your people can, or whatever. Yep. But I think that's just something to think about. And because what's going to happen is once the briefing cycle is completed, and I'm putting that at July, June is when everything's going to be fully briefed, the response brief and the reply brief. Now you're going to talk about a desert of 6, 8, 9 months.
Yeah, waiting.
And what would really be terrific is when it comes back and hopefully, it is reversed. Let's pounce and did a speedy trial out there. How can you do that? Well, get all this information out there, and maybe you get a new prosecutor on there too, maybe a new judge, and you can go to these people. There are some prosecutors you can actually go to and say, hey, I want to talk to you about the problems that you have with your case. Right. And it's part of the problem that I've had with this case is I'm a very transparent defense lawyer. I mean, I'm strategic, but I'm also very transparent. I'm usually walking in and saying, hey, I'm throwing you a 95 mile an hour fastball right now. You got to hit it. And I'm telling you exactly what I'm doing at trial. But when you do that, there can be problems with
double-edged sword, no question about it. But look, I mean, Osbrook is very much of the mindset that there is enough in existence that is, again, coming all from the discovery that was tendered by the state of Indiana, to where they can be convinced not to retry Richard Allen.
Yes. Well, especially if the fruits of the poisonous tree preclude the bullet and the gun from being admitted into evidence. Now you've got Jerry Holman in a deposition saying, if it weren't for that gun, we couldn't even have arrested Richard Allen. I mean, you got the lead detective saying that in a deposition, and that creates a major problem. So, there's a lot. I'm excited about the future. I'm sad that Richard Allen's spending another Christmas away from Kathy. And you just hope, I think he's doing better in Oklahoma, and what I was worried about before, I think I'm kind of okay with now. But you just got to get, as I do every morning, pray for the real killers to come forward. Still praying every morning for that, and praying for Richard and Kathy to have good frames of mind, and that the person that comes forward goes to an honest cop and provides real information that could bypass all the need for everything that we're talking about. Because I do believe ultimately, and I'll finish with this so you can go on, but for those who think that I don't believe in Richard Allen, and this is all those people that might say, oh, you're in it for the, you're in it for the glory or whatever. Listen, I've gained about 90 pounds since the trial. I don't like being on screen, because it adds 50 pounds. But I'm doing this because the word needs to get out there. And everything that I believe Richard Allen, without any doubt, without any question, is innocent. Okay. For anybody that thinks this is all about, it's book deals or anything, there is nothing like that going on here. You know, my firm has lost a lot of money because of this case. We have expended lots of money on this case because we believe Richard Allen is innocent. And there is no question in my mind. I would stake my life on it. Okay. There is no doubt that Richard Allen is innocent. There is multiple people involved in this. And the state police know it. The FBI knew it. Everybody knows it. And the person that was not involved in this crime was Richard Allen, who has no ties to anything Norse paganism or anything like that. Richard Allen is innocent. And that's why I'm on this show and will continue to fight. Whether, you know, it's a good idea, I don't know. These things will be found out later on. Maybe this hurts me from getting back on the case. I don't know these things. But I'm excited right now, and I'm optimistic. So
today,
well, I can tell you,
day of hope, man.
Yeah.
And I was just going to say, people that have followed this case, they don't need you to explain that this isn't about a book deal or a movie deal. Everybody knows that you're a genuine person and how this has affected you emotionally, and how innocent you believe your client to be. So
thank you. Well, thank you, everybody. Hey, keep up the good work, and I'll.
We will, man. We will.
I know you will. And thank you to everybody out there, and we'll talk to you.
We love you, buddy. All right,
thanks, guys.
Bye. Merry Christmas.
All right.
Pull it up.
So Andy is the forever gentleman, and he won't discuss the shortcomings of the brief overall. We will maybe not necessarily today, because we've got to get through all of it. So is our plan still at this point?
Yeah, let's keep plugging along. And just so I wasn't looking at the chat.
Did we ask him?
And you know who you are out there. There's no part of me that's just talking. Everything that, if you don't know by now, that the shit that I say, I mean, I don't play the just talking game. So, you know, look,
my man don't just talk.
The hope is that he gets a new trial off of this appeal. If he doesn't, I mean, I very much wish that the post-conviction investigation was in full swing right now. I know that there's work that's being done behind the scenes, and you know, I mean, look, this is we called this live, you know, the long road to freedom for a reason. So, all right, let's keep rolling, babe.
So, just so we're on the same page, you want to get through the issues and save the statement of facts, or are you going to want to go through the 50 pages of statement of facts now as well?
Let's keep rolling. Let's go until I fall off this ball.
All right. So we started with issue 1 on it, and we talked about some of that with Andy as well. So these are the omissions or false statements that Liggett made to get the search warrant for Richard Allen's home. Without that warrant, there's no bullet comparison. None of that evidence gets in. So, and then 4 is just that the error requires reversal. Oh, again, we talked about, and possible remand.
Yeah, that's where we ended at B, I think.
Okay. So 2, the trial court erred admitting the statements Allen made while gravely disabled during an unprecedented pretrial solitary confinement in a maximum security prison. Now, this issue is twofold. First, they're going to deal with the constitutionality of the statements themselves, that whether it was a violation of the Constitution to admit those. And then later, we're going to get to the evidentiary issues about why those were relevant, even irrelevant, and shouldn't have been admitted, even if they were constitutionally obtained. So they discuss the standard of review and indicate, oh yeah, you talked about this, how the trial court refused to admit that order settlement into the suppression hearing. And then C, the state failed to prove Allen's statements made while gravely disabled were voluntary. So they start with the U.S. Constitution. The state failed to prove that Allen's statements were not the product of psychological coercion. Now, it is the state's burden when you file a suppression motion and you argue that it was not voluntary. The state has to prove it was voluntary. So that's that issue there. A, the state prolonged solitary confinement of Allen was state action. B, the state's prolonged solitary confinement was psychological coercion.
Truth.
C,
Truth.
Allen's confessions were the product of solitary induced psychosis, not rational intellect. So again, we're talking about here, you need state action in order for even to be discussing the US Constitution, which is an issue here when you're talking about the family calls. And we'll see as we delve in later the difference here of how this brief likely handles statements made to a guard versus statements made to the family. But either way, you're saying the state's action of confining him puts us in a constitutional framework.
Right.
And the state's same thing with the and then that the solitary confinement was psychological coercion. You can imagine the law for a long time just dealt with physical coercion.
Right.
Physical coercion, physical coercion. It took a while before psychological coercion, was something that they used to determine whether or not a statement is violated the Constitution. So then
And
they're going to
this is different, right? Because when they did start to address that as a reality in terms of some of these interrogation type situations, it was in a very protracted period of time. This was different, right? This was over an extended period of time, and it was done in a vastly different way.
right.
And it's like the argument they're going to have to overcome, and I'll never forget the way that McClellan just kept trying to couch it. Oh, this wasn't solitary confinement. He was in a single person cell. It was the most disingenuous, disgusting explanation for what the state was doing that I've ever heard. And again, it's like that thing where you just need to hope that somebody, either like the law clerks, that somebody is digging in to the actual evidence, when they're reviewing everything that is in front of them. Somebody's got to read, somebody, whether it's one of the judges themselves or one of their law clerks, has to read the Franks memo. I
Right.
mean, like that, it's a partner piece to the appellate brief. It really is.
Yeah.
Because without them being able to flesh out all that is contained therein, they're missing a huge part of the actual argument, because like, again, and you're the appellate brief writer in the family, and how hard it is to stay within that word limit. It's like I've seen you like in the most epic battles with yourself, trying to call down words and things that you're trying to figure out, like, what can I take out, because everything feels that it's absolutely critical, so it's like it's a frustrating thing, but it's a reality. And in the only workaround in terms of this is the fact that particular document, and like, really, yes, there's 1 through 4, but Frank's memo 1 is the one that I just hope against all hope that somebody actually reads from beginning to end, because it's that thing, right? It's that, like, I dismiss everybody like it's fantasy and all that, like, whatever, dude. Like, anybody that dismisses anything offhand when there's demonstrable proof that it exists in that area, like, beyond the fact that prison guards or the prison guards are wearing patches. I mean, when you're talking about Delphi itself, it rocked me to my core to know that the tattoo parlor was named Odin's Den. I mean, what? Like, this like, it's a thing that exists in the world, and I don't know whether or not these 4 or 5 individuals that are named in that memo did the damn thing. But what I know is there's stronger evidence against them that they did than there is against Richard Allen that he did. That's the bottom line. And the jury had to hear it. Those are factual issues for a jury to decide. and when she cut him off at the knees and didn't allow for that to happen, it was a devastating blow to the defense team and to, most importantly, to Richard Allen.
Right.
Well,
So turning back to what we're talking about here about um what they have to overcome to have this be deemed psychological coercion. You have to think of it, typically you're talking about someone's in a police station, right? And the police are waiting to interrogate you. So they don't feed you. They don't let you talk to your family. They keep you in a room for days and they keep waking you up. That's a huge ploy. They sleep deprivation. Every time you start to doze, like, oh, come on, we got to move rooms. You're
lights
going
are
over
on
here.
all the time.
The lights are on all the time. So that has been deemed psychological coercion, or like, some kind of threats about like what might happen to you if you don't speak and, things like that. But this is a completely different scenario. So they're having to apply the legal framework we have for psychological confinement coercion to solitary confinement in a prison when they're not waiting to interrogate you, but they put themselves in a position where you can be overheard what you're saying by state actors, which Bob and I feel was 100% intentional.
Well, like I've said this a million times, and it's the gospel that and if we could ever get an honest broker prosecutor on here that's probably not in that office anymore or doing that job anymore, and you were to ask them, all right, look, if you've decided to move forward on a case and you have at best very tenuous evidence against the person that you've decided to move forward on, how important for you is it that that person confesses to something while they're detained awaiting trial? Like in this case is a perfect example of that. When you look at on its face the evidence that they had against Richard Allen having committed this crime, you have to know they needed they needed those confessions. And they weren't in a position anymore because they had pressed the charges. They were charging him. They knew he was going to be held and detained. They knew that he wasn't going to be able to put up bail if it was going to even be offered by a judge, which they assumed that it wouldn't. They knew at that point that they're going to have to extract the confession from him somehow. And this is the way that they did it.
Right.
And it's like the thing, and did you get into any of the argument here or in terms of the statement of facts? Because the one thing that can never be undersold about Richard Allen's mental state going into that facility is that his mind was a fragile eggshell. He had known mental illness going in. I mean, he had the major depressive disorder, and that the dependency issue. What do they call that? I keep forgetting what that thing is that he has, that disorder, the dependency disorder, wherein when they were able, because I would always see it from the other side. Oh, what are you talking about? He got to talk to Kathy Allen whatever he wanted on his tablet. I don't give a shit, because this is a guy that woman for 35 years, since they were teenagers, was his rock. He would have killed himself decades ago if Kathy Allen didn't exist in his life. And when they cut off his ability to lay eyes on that woman, that did more damage to him psychologically than anything else. And I will die on that hill.
And he would implicate himself
It
if he
broke
thought
him.
it would make things better for Kathy.
Like always, everything that he did and said that it was in relation to Kathy was to try to make her life easier. Like he was willing to sacrifice everything in order to make his wife's life easier, to try to ease her pain of her having to be on the outside while this shit was going on. Their family's been destroyed. Their life has been destroyed. You know, I mean, it's like I hope they get into that stuff, because that particular aspect of Richard Allen's psyche, that was the breaking point for him. Like there is no doubt in my mind when they cut him off from just being able to lay, for the comfort of being able to lay eyes on the woman that is his everything. It broke him. It's that simple. Like this guy came in, you know, the most delicate that you can imagine in terms of his mind, state of mind, and they fractured it with ease, you know. And it's like I don't even know that the you know, the child killer and all that shit, everybody screaming and all that, I don't know that any of that really mattered. What mattered is they took away his safety blanket, his life safety blanket. And when they did, this is what you got. You got a guy saying the shit that he said in order to either get moved out of that facility, you know, because that was always the thing. Oh, were they beating the shit out of him? No, they weren't. They didn't need to. They didn't have to beat the shit out of him. All they had to do is say, hey, man, you want to see your wife? You want your wife to be able to come and visit? Just tell us you did it, bro. Shit's simple. You want to get the fuck out of this hellhole? Just tell us you did it. This is a
Right.
simple thing, bro. That's as easy as that was for them.
All right. So then they turn to the Indiana Constitution with a slightly different standard than under the U.S. Constitution, that the state failed to prove Allen's statements were the product of rational intellect. But this part's important because it's rather than the state's misconduct. And again, you have to think about this in the typical scenario. You're in a police department. You're talking about cops actually interrogating people or, you know, trying to get them to speak, not this situation where someone's I mean, it doesn't happen, right? Someone's in prison pretrial and they're in solitary confinement, and, you know, then they happen to make some sort of statement that's inculpatory. So it's going to be a hard battle to apply both the Illinois Constitution and the Indiana Constitution, the legal framework that the courts use in deciding these cases, to the facts of this case, because there was no interrogation.
Right.
And again,
That goes to exactly what you're saying. I mean, it took them a very long time to appreciate the concept of coercion in the traditional sense. Because that's what I was telling you after Rosie made the argument. You know, this was just a different form of it, you know, and one that hasn't been addressed. So when you see the reticence of them saying, okay, yeah, that coercion thing is a thing, and we do believe that it results in involuntary confessions and admissions by people. So when he's introducing another level of that is just not operating in the way that they traditionally do, being law enforcement, it's a real uphill battle. It really
and the
is.
courts have recognized that solitary confinement is a form of psychological coercion, and that it can cause, um, you know, it can cause people to make false false statements. But
But I always
again,
thought the counter, like we've had this discussion, I've always thought that the counter argument to that is, well, what's to say that that isn't what drove him to give an actual confession, a true confession? You know, I mean, that's always devil's advocating. That's why I'm telling you, the thing we're in, it's you look at this dependency disorder that he had, like in conjunction with his anxiety and his depression. That move of separating him from being able to lay eyes on Kathy and just know that she exists beyond hearing her voice on a tablet, which he didn't trust anyway. I mean, you know what I'm saying? It's like he didn't know who he was dealing with. He didn't know if his attorney, like when you're listening to those things, and he's like, well, you know, these attorneys are coming to visit me, and I don't know if they're really my attorneys. I mean, that's where his mind was at. Like when you're sitting there losing your shit and you're hearing a voice through a tablet, shit is just absolutely surreal. Like nothing's like you cannot delineate between what's real and what's not. You know, it's like, oh man.
all right. So And then 4 is just that the error was not harmless because which is okay, even if the court finds so D is even if the court finds that Allen's statements were voluntary. And that means voluntary under the Constitution as far as what it recognizes. They are the product of unconstitutional detention. Allen's prolonged solitary confinement violated Article 1, Sections 2, 12, and 15, and the constitutional violations require suppression. That is also going to be a very novel type of argument. And E, the error was not harmless. So then 3, and this is basically the final issue. It includes a lot of sub-issues, but 3, the court denied Allen his right to present a complete defense, to explain the scene, and to impeach the investigation. Now, that's one thing I wanted to ask when we had Andy on, and I'm sorry I had to go. It was an attorney general calling me. Did you happen to ask him if that the evidence being relevant to impeach the investigation was a discussion ever had in relation to the evidence that she excluded in third party culprit?
You asked me if I asked Andy.
Right.
No, because you left and you didn't have the document up anymore. So we weren't getting into the, with Andy, we weren't getting into the, into the thick of it because,
Well, I thought it was good to just give his overall, thoughts, and then people, as we go through this, they can have that to kind of relate back to.
Yeah, I mean, anybody who wants to see Andy's thoughts on it, we've had him on the show so many times. I assure you, he has talked ad nauseum about the crime scene, their lack of ability to be able to discuss it. Like the only thing that they ended up getting in that was relative to the crime scene potentially was the fact that they found that large stick in that garage, like the limb. I mean, it's like, how do you explain a fresh cut stick at the scene? It's like all the things that you would have like really wanted to dig into. That's what I'm saying. Like, somebody has to read the Franks. Please, somebody read the Franks.
All right. So the first they discuss, A, is the standard of review, and B, the court committed reversible error by excluding Blair's sketch of Bridge Guy. So most of you know what that is, and I'm just going to pull it up here for anyone who does not. That is her sketch of Bridge Guy, which looks.
And what's most significant is the fact that she sees Abby and Libby. There's no one else. Not another witness exists. Well, she claims that she sees two girls.
But if she saw this guy, babe, on the screen now, how would she even know what his hair looked like?
I don't know.
He's wearing a skull cap or a hat, whatever the case may be, whatever they want to call it. How does she even? I mean, he looks nothing like this human being, but how would she even know about his hair?
I mean, that's what goes to multiple people were involved with this. It's the only thing that makes sense to me. Because that guy, like, as blurry as that is, that guy doesn't look young.
Or she just happened to see some other guy. There was a ton of people out there. Who knows?
But here's the thing. There weren't a ton of people out there. And she says that when she leaves that she sees the two girls coming, and the timing is that I feel like it has to be Abby and Libby.
Right.
So she sees this guy. She turns around to leave, and she sees the girls going onto the bridge.
Right.
Which, I've always been of the mindset that whoever abducted the girls came from the south side of the bridge. Like no one can explain I've never seen any kind of explanation as to that 207 picture of Abby on the bridge where you can see all the way down to where they have the little blockade, and you can see, the little, whatever the hell they call those things that you stand on. And there's nobody on that goddamn bridge.
Right.
207.
Yep. And then C is the court committed reversible error in excluding Tobin's testimony. Now, Tobin was the proffered defense expert about the bullet to explain why you can't use an unspent casing and a fired bullet to determine that there's a match. And the judge wouldn't allow that in. So D, the court committed reversible error in admitting hearsay to rehabilitate the timeline upon which the state built its case. Now, Bob and I, we didn't get to this portion, are assuming that is the, hold on. That's not it either. That this could be the van. Okay, so here, the state built its entire case in the following timeline. Allen encountered the girls at 2:13. He completed the murders alone, left LG's phone at the murder scene, was spotted by Carball leaving the scene at 3:56 and never returned. So now they're talking about the wired headphones. So it is about Cecil. That's what I thought at first. So that's their point there, is they let Cecil talking about the headphones in to just change the entire timeline.
Yeah.
Yeah.
As opposed to the white van and Brad Weber's lie.
Right. So, I thought it could have been the
See, but that's all post-conviction stuff. Like that like if they don't vacate it, if this isn't successful, I mean, you immediately go over to post-conviction and all the new evidence, that's when it's coming in. That's when all the things that have been uncovered, it's all coming in.
So E, the court committed reversible error by excluding evidence that impeached the credibility of Allen's confession.
No, the white van's not post-conviction, but in terms of...
Well, some of it could be.
So, right. Some of it could be in terms of the fact that the question is going to become this video that shows that Weber really was driving down that road 9 to 12 minutes after the state claims that the homicides took place, like whether or not that's newly discovered, that's going to be the thing.
Right. So here, this E, which is, a subpart of their third issue, that the court committed reversible error by excluding evidence that impeached the credibility of Allen's confession. As I was discussed yesterday, and we'll go through again today, now you have an evidentiary question, whether or not the juries need to understand the circumstances surrounding his confession in order to determine whether or not it's credible, whether or not it's reliable. So that is different than a constitutional question. Now this is going to whether and that's why the standard here is, was it reversible error for the judge to do that? And there's a couple of things that they get into. One is the court erred by excluding the audio from Allen's solitary confinement videos. And Bob, go ahead, for those who weren't here yesterday, remind the people of that.
What? I wasn't paying attention.
Oh, sorry. So if you guys recall, at a pretrial hearing, the state said, there's no audio on these videos of his solitary confinement. And then the judge said she excluded the audio from all of the videos. And I think she did it saying that it was hearsay, but nobody really knows for sure. So that's one of the issues they're saying. She should have allowed the audio from those videos. 2, the trial court committed reversible error in prohibiting the jury from hearing 2 phone calls Allen made on April 3rd, 2023. Now, we did a whole separate live where we played the recording and we went through the transcript of how that all went down. But that's the recording that Rick makes, the call that Rick makes to his father hours before the confession, saying, I didn't do this thing. don't believe words I say after this. I'm going crazy. All of those things. So that's the exclusion of the phone calls. And then 3, the trial court erred by excluding the statements and behaviors that provided the foundation for Dr. Gracian?
Yeah.
Opinion that Allen's confessions were not credible. So what's that about, babe?
So Gracian, he was the guy that I was telling you, and I would have liked to actually hear more testimony from him, but Gracian was really the guy that was talking about memory, right? So, and he was explaining that concept that our memories don't work, wherein you're remembering the event itself. What you're remembering is the last time that you remembered the event. So as you continue to recall this thing, all you're doing is recalling the last time you remembered it. So if you've, it's like if you've told a story about something that happened or didn't happen, and you're trying to recollect it, and you're like, let me think about it for a minute. All you're doing is remembering the very last time that you remembered it. So whatever's changed in terms of the last time you remembered it through all the different times that you have remembered it, all the kind of telephone game type things that might happen with your memory in terms of adding things, not including things being just completely born out of your own mind that didn't happen at all. Those things are all, it's cumulative in the sense that you're really only remembering the last time that you remembered that specific event. So,
right. And I pulled
and
up
his thing was, like, and it all goes back to Walla, really. At the end of the day, these conversations that she's having with him. And I don't know if they bring Walla up. I mean, like, to me, Walla was an arch villain in this case. The shit that she did, just her in there, her having access to him, being this true crime junkie and, having dug into this case to the extent where she's gone out to the trails, gone out to the bridge. She's accessing things on the system in the facility that she's not allowed to access, to look up people's criminal backgrounds. And she's unbelievable. Like, I mean, the shit that she did and the things that she could have, like, no one is ever going to convince me that woman didn't plant. If Richard Allen actually said, like, the detailed confession that they used is, this is the shit that only the killer would know. Here's the one we needed. Here's the one we needed, that the I did it shit, and maybe I did it, and they're telling me I did it. Evidently I did it. That's not good enough. Like, we need him saying, all right, we need some facts. And the reality is that there's, like, where's all the video of Walla with him? Like, he's being surveilled 24/7.
I thought they said that was the only place they didn't have it because she's the psychologist.
Pretty convenient.
Yeah. So I highlighted that portion that basically you're talking about here from the statement of facts with Dr. Gracian, that Allen wasn't, and he's a psychiatrist experienced with solitary confinement cases. So he says that Allen was delirious and saw signs of a false memory common in delirium, where a belief evolves into a perceived recollection. Some people will say, I think I did it, and after a time start perceptualizing the event. The more someone tries to remember, the more concrete and distorted the memory becomes, like a game of telephone. Oh, I was going to say, hi, Scout. Congratulations. Good work. I'm so proud of you. Come down and give mommy a kiss when you're done with daddy. All right. So then you've got F. The court committed reversible error in denying Allen's motion to correct errors. So that's going to bring up all the issue in the motions to correct errors and say the court should have been granted. G, the trial court committed reversible error when it excluded Allen's evidence pertaining to explaining this murder as a ritual killing. And then H, the trial court denied Allen's right to show the state's investigation was incomplete, overlooked plausible leads, and mishandled evidence relating to third party guilt. And when we get to that section and when we go through the statement of facts, we will be on high alert to see if that's an argument the defense ever raised. Did they, in fact, say, hey, Your Honor, this doesn't only go to third party suspects, it also goes to the extent of the investigation, the failures of the investigation. And again, those of you who watched the Karen Reed trial would think of that as Bowden evidence. And I did some research, and then we talked to Michael Osbrook, and there is no corresponding like watershed case in Indiana, but Michael says, of course, evidence that speaks to the issues in the investigation are admissible. So those are our issues. They get fleshed out, when we get deeper into them. And we're going to have Michael on when we do that part of it, when we get really into the fine tuning of the issues. But Bob, I know you want to start the statement of facts, and I wonder, is there a certain section that you think might be, because we're never getting through all 59 pages right now. And they did a really good job in this case of kind of breaking down the statement of facts into kind of areas of topics. So do you want to start at the beginning, or is it possible you might want to go to a certain, area, and if you're talking, you're muted.
I was in fact talking. Let's see. Do you want to go through the were the three issues presented? Were they kind of together? I mean, they're short. Why wouldn't?
Yeah, no, and I thought I might have read those already before we.
Oh,
but we can definitely do it again. So this statement of the issues is an abridged version of what they said earlier, what we just went through. So whether the search of Allen's home was unconstitutional and the resulting evidence inadmissible because law enforcement omitted or altered key facts in the warrant application. And then that, as we know, covers way more than that. It covers the Franks hearing. It covers but this is a shortened version of it. 2, whether statements Allen made while gravely disabled during unprecedented pretrial solitary confinement were involuntary, the product of unconstitutional detention, and inadmissible. And then 3, whether the trial court denied Allen's right to a fair trial to present a complete defense, to explain the scene, and impeach the investigation, which encompassed the whole litany of things that we just went over.
Okay. Yeah. And just like the statement of the case is just the very brief procedural history. So yeah, let's just go through the statement of facts real quick. Like if we lose steam. So I'll read, you scroll, because I have it up.
All right. So do you want me to read the statement of the case?
Well, sure. Yeah, it's short. So
on October 28, 2022, the state charged Richard Allen with 2 counts of felony murder by kidnapping, which was amended March 22nd, 2024 to add 2 counts of murder. On November 11th, 2024, following a 25-day trial, the jury returned a guilty verdict on all counts. The trial court sentenced Allen to an aggregate sentence of 130 years. Allen filed a motion to correct errors, which the trial court denied.
All right, so statement of facts. On February 14th of 2017, 14-year-old Liberty German and 13-year-old Abigail Williams were found dead in the woods. 2 days later, Allen, like many others, came forward and reported that he had been on the trail that day and saw 3 girls. Now, anytime that you're seeing those citations, so you'll see those all throughout the brief, right? You're always going to see when they're citing the record. Okay.
Right. So we're not going to be like, we usually will go down and read a footnote. We know that that's just a citation. So we're not going to be doing that for every. Yeah. So, but sometimes we might get to a section where we're like, oh, I wonder what they're citing here. And it'll be interesting to go and look. But this is just kind of, overall details right now.
Yeah. Because law enforcement wanted to know whether he had seen any, quote, possible suspects, he was interviewed in a parking lot. After the interview, the lead was marked cleared and the report was misfiled. Allen then returned to his job, his family, and his home in the small Delphi community. For the next 5 years, he did not sell his car, destroy his clothes, dispose of his gun, or relocate, but continued his normal routine. No witness identified Allen as Bridge Guy.
So now what's missing here is any kind of citation. So they just said words with no cite to the record in a statement of facts, which is, somewhat of a no-no.
Well, I mean, in terms of no witness identified Allen as a Bridge Guy, it doesn't exist in the record.
Except I would have went to cited to the areas of the witness's testimony.
Yeah.
Yeah. And I don't know where these facts come from,
Yeah.
these other facts about he continued his normal routine, like, is that a fact and evidence? I don't know. And they surely didn't tell the
I mean,
court.
it is in terms of testimony. So, all right. So when the report was rediscovered in September of 2022, law enforcement insisted Allen was Bridge Guy without a single eyewitness. Over the next several years, the state built its case against Allen. So 1A, the Bridge Guy video. So on February 13th of 2017, around 1:30 p.m., Liberty German's older sister dropped Libby and Abby off at the Monon High Bridge Trail. So they have a typo there, to explore and take photos. The girls had the day off from school and the weather was unseasonably warm. When the girls failed to meet Libby's father at the specified time and no one could reach them, Libby's family contacted police and an extensive search began. The next day around noon, the girls were found murdered in the woods near Deer Creek, not far from the High Bridge. The best evidence law enforcement had was from Libby's phone, found at the scene under Abby's body. Libby recorded a 43-second video.
Wait, at
what?
At 2:13.
Oh yeah, sorry. At 2:13:51, Libby recorded a 43-second video showing Abby walking across the bridge with someone, parentheticals, Bridge Guy, behind her. Law enforcement enhanced the video, yielding the following. So you got your picture. The man is heard telling the girls down the hill. Law enforcement set up a tip line and many people came forward. 16-year-olds, RV, which is Rayleigh, and her sisters, that's Rayleigh Voorhees, and her sisters IV and AS, and her friend BW told police that they were on the trail. And as they were leaving, they saw a man near the entrance to Freedom Bridge. So if you're not familiar with the scene, Freedom Bridge is, I don't know, how long did it take? Like, I was walking briskly by myself, and I think it took me about 12 minutes to get from Freedom Bridge to the High Bridge, like going down the trail system. So Betsy Blair, who frequently walked the trails for exercise, came forward and told police that she saw a white man on the High Bridge standing on a platform, and he seemed to be waiting for someone. She thought the man was the guy in the video because he was wearing the same clothes. Now, when she reached the bridge, she turned around and noticed two girls approaching. 4 months after the murder, law enforcement interviewed Sarah Carbaugh. She told police that on February 13th, while driving eastbound on County Road 300 North, she saw a muddy man wearing a tan coat walking west towards town. After seeing the image of Bridge Guy in the media, Carbaugh said that he possibly was the man she had seen. 5.5 years later, on September 21st of 2022, law enforcement rediscovered the tip from Allen. In the February 2017 tip, Allen called and said he was on the bridge between maybe 1 and 3, and that he saw 3 girls. Allen shared his address, his phone number, and his MEID number, which is the unique identifier that can be used to track a phone's location. The lead investigators immediately started investigating the now 50-year-old Allen. They believed that the man the 4 girls, RV and the others, saw on the trail was Bridge Guy. Alan still lived in the same house, worked at the same CVS store in Delphi as he did in 2017. On October 13th of 2022, when police showed up at his house, Alan agreed to talk with them. After riding to the police station or to the station with police, Alan patiently answered questions about his personal life and the walk he took on his day off 5.5 years earlier. Alan explained, after spending the morning with his mom on February 13th of 2017, he went home to get a jacket before going to the trails. He walked out to the first platform of the high bridge, looked at the fish, and then walked back before returning home to watch the stock market. He explained that he came forward after law enforcement asked to speak with anyone who had been on the trail. The next day, a DNR officer interviewed him in the parking lot. Alan believed that he told the officer he was on the trail between noon and 1:30 or 1:45. He could only recall seeing 3 girls leaving the trail. Being 5 years past, Alan could not remember what car he drove or the clothes that he wore. He remembered wearing blue jeans and a jacket. When asked what type of jacket, Alan did not remember and listed all the jackets that he owned: a blue Carhartt, a black Carhartt, or an off-brand with a hood, sweatshirts, hoodies, and a fleece. He kept a skull cap in his jacket. He could have been wearing tennis shoes or boots.
So I kind of thought it was odd that they said he remembered wearing, because I think what he said was, I was probably wearing. So I would have maybe worded that he indicated it was likely he was wearing, but I mean, because they're like, he couldn't remember what clothes he wore, but then they say he remembered wearing blue jeans and a jacket.
Yeah, no, I agree. I mean, obviously they have the interrogation videos. I mean, the question is anybody going to look at them? Is anybody going to review them? So when law enforcement asked for a consent to search, Alan expressed concern that they were making him, quote, somebody's fall guy by trying to fit pieces together that do not fit to close the case. He was confused, thinking that they were talking to him to look for, quote, helpful information. Although he understood that they had to clear everyone on the trail, he was bothered by the passage of time, or the time passage.
I would say he was more bothered when it got confrontational, but whatever.
Yeah, I mean, he said it pretty early before it got, because that was really with in the first interview when he's like, starting to get the sense that you guys are trying to pin this shit on me. So after a break, law enforcement returned more confrontational with Alan, who became frustrated with being accused of murder and law enforcement contacting his wife and daughter while he was at the station. Confronting Alan with the bridge guy photo, Alan responded, quote, if that is taken with the girl's phone, that is not me. I have never met those girls before, end quote. They accused Alan of admitting he wore the same clothes as bridge guy, and Alan corrected the investigator, reminding him that he said that he could have been wearing a sweatshirt. Alan added that everyone has looked at the bridge guy photo for years. To him, did not even look like bridge guy was wearing a Carhartt. Finally, when law enforcement accused him of either being out there to kill the girls or to introduce them to someone, Alan said, quote, good luck finding anything that points to that, end quote. Despite Alan repeatedly telling law enforcement, quote, arrest me or take me home, end quote, they would not stop. Alan eventually had to get up and walk out to end the interview. C, the story Detective Liggett told the judge. On October 13th of 2022, the state applied for a warrant for Alan's home, car, and electronics. In Detective Liggett's probable cause affidavit, he concluded that, quote, Alan is the last individual to have contact with LG and AW, and is, quote, is the individual depicted on the Monon High Bridge from the video taken from LG's phone, end quote. He reasoned that Alan admitted that he was wearing a blue jacket and head covering like bridge guy, and it was on the trail and bridge around the time of the abduction, and the witnesses, the 4 girls, Blair and Carboss, saw a man they believed to be bridge guy wearing a blue jacket. Detective Liggett implied Blair and the girls saw the same man because they similarly described his jacket. Also, Detective Liggett concluded that Allen drove his black 2016 Ford Focus and parked at the old CPS building on 300 North. He claimed that witnesses Blair and Wilson saw a car backed into a parking spot at the CPS building. Wilson felt the driver of the car was trying to conceal the license. Wilson said that the car was a purple PT Cruiser or small SUV type vehicle. Blair and Wilson drew a diagram and had the vehicle they saw parked in the same general area and manner. D, the part of the story Liggett did not tell the judge. 1, Blair's description of bridge guy did not match Allen. Detective Liggett did not tell the judge about the differences between Blair's description of the man on the bridge and Allen's appearance. Just 3 days after the murders, Blair described the man as white, age of 20, of medium build, and having brown curly hair. An artist completed this sketch, which Blair rated a 10 out of 10 for accuracy. In 2019, Liggett personally interviewed Blair, who again described the man as slender, youthful, quote, boyish looking, in his 20s to early 30s, no facial hair, and with poofy hair, like the sketch portrayed, which she still gave a 9 out of 10 in accuracy. At the time of the murders, Allen was 44 years old, 5'6", and had very short hair. Detective Liggett, 2, Blair's description of the oddly parked car did not match Allen's. Detective Liggett also omitted Blair's description of the oddly parked car as resembling a 1965 Ford Comet with sharper angles.
Okay, so that explains why it wasn't in the argument portion, because they put it here. I would have cited back to this, but I'm glad that it is in here because it's not in the argument. I don't know why they didn't put it in the argument, but they didn't.
So below is her drawing of the car compared to Allen's hatchback.
I wonder if these words count.
Like that space.
No, the appellant's brief, Richard Allen. If those words count, I would assume they do.
I assume that they do. So Blair said the oddly parked car was a nondescript color, but not black. Allen's car was black. 3, Blair did not believe the man on the bridge was the same man Carbaugh saw walking down the road. Detective Liggett omitted that Blair told him that the man Carbaugh described walking down the road is not the same man that she saw on the bridge. Below is Carbaugh's sketch. I mean, I think not. So after talking,
that looks like bridge guy.
Yeah, I mean, that looks like a bridge guy. So after talking with Blair in 2019, ISP issued a press release distinguishing the man that Carbaugh saw from the man on the bridge. The ISP explained that the men, quote, are not the same person, and that is bolded for emphasis, and that Blair's sketch is, quote, is representative of the face of the person captured in the video of LG's cell phone. 4, Carbaugh said that the man walking down the road was wearing a tan coat. Detective Liggett also made false statements in the affidavit. He claimed that, quote, an interview was done of Sarah Carbaugh in 2017, end quote, and that she stated that she saw a man, quote, wearing a blue-colored jacket, end quote, and, quote, was muddy and bloody, end quote. Carbaugh did not describe the man as bloody, only muddy. She said he was wearing a tan jacket. I mean, he just made shit up there.
Yeah.
So Allen never said he was wearing a blue Carhartt, and his wife said Allen had purchased his current Carhartt a couple of years earlier. So Detective Liggett falsely stated that Allen said that he was wearing a blue or black Carhartt with a hood and a head covering up. Allen told investigators that he did not know what he was wearing, and it could have been anything from a Carhartt to a sweatshirt, and that he kept his skull cap in his jacket. Although Allen's wife said that he had a blue Carhartt in 2022, Liggett left out that she said that Allen purchased that coat a couple of years ago, and that's in quotes. The girls were killed in 2017. The warrant. The trial court issued the warrant. Law enforcement seized from Allen's home multiple items, including a Sig Sauer gun, knives, casings, and the Carhartt type jacket with a yellow and white and yellow patch on the front pocket. These items featured
Okay,
prominent.
sorry. That footnote is kind of relevant. Bridge Guy's coat does not have a patch like Allen's.
Yeah.
And then it also says the 3C footnote 3, which I don't know where it is. So we'll just go back to where we were. Sorry.
Where it at?
Because it says add 3. So I didn't know if that meant, also see. Oh, addendum 3. Sorry.
So these items featured prominently during Allen's trial. F. Allen denies the bullet is his, that he was Bridge Guy, or had anything to do with the murders. At the scene, officers found an unspent, unfired 40 caliber Smith & Wesson cartridge near Libby's right ankle. When ISP analyst Melissa Oberg cycled 6 cartridges through Allen's gun, she did not find any marks that matched the marks on the cycled round at the scene.
I mean, this is huge.
Yeah.
And that's what people that don't know this case very well need to understand. She cycled it 6 times and could not make a match.
Right.
Go ahead. Sorry.
No, that was important to say. So thus, she could not establish a link between Allen's gun and the unspent round at the scene. Oberg then fired 4 cartridges from Allen's gun. She compared
apples to oranges is what she compared, right, babe?
100%.
Because again, this was an unfired casing. You're supposed to find the similarities between she racks the same gun and gets the same markings on an unfired casing. She couldn't do it.
Pressure matters. So Oberg then fired the 4 cartridges from Allen's gun. She compared the markings on these spent cartridges to the markings on the unspent cartridge at the scene and concluded that Allen's gun was the source of some of the markings on the unspent cartridge at the murder scene. After learning of Oberg's conclusion on October 26th of 2022, law enforcement interrogated Allen again for about 1.5 hours. Detective Holman accused Allen of killing Abby and Libby, or at least being involved. Allen explained the, quote, very day, end quote, the police asked anyone on the trail to come forward, quote, that is what I did, end quote. I went for a walk on the trail and went home. And, quote, I did not murder 2 little girls, end quote. Detective Holman repeatedly confronted Allen with Oberg's conclusion that the marks on the casing at the scene, quote, matched his gun. Each time Allen denied that the bullet at the scene was from his gun. Holman even claimed that the methodology was, quote, scientific and like, quote, fingerprints.
And then for those of you just to know, that's literally what Holman is telling Richard Allen while he's interrogating him. He's like, this is like a fingerprint. It's scientific. This is it. It 100% came from your gun. And that is also what he was telling Richard Allen's wife.
True story. Exhausted and frustrated by Detective Holman's relentless accusations that he murdered Abby and Libby, Allen consistently said that he could not tell him what happened to the girls because he does not know. He did not know how that round got between the girls or how they died. He emphatically stated, quote, I did not murder 2 little girls, end quote. Despite Detective Holman's lying about experts identifying Allen and his voice in the video, Allen continued to deny that he was Bridge Guy. Detective Holman tried a different lie, saying 5 witnesses saw Allen with Liberty and Abby and a gun. Again, Allen said, it did not happen, quote, and I don't care how stressed out I get, I am not going to admit to something that I had nothing to do with, end
So
quote.
just to pause right there, as far as I see thus far, there is no argument that these interviews should not have been admitted, that they should have been suppressed, although they're taking the time to put these facts in when they've got very little space. Now, do I think they're important facts? Sure, just kind of for context, but maybe that should have given rise. You're setting out facts that speak to whether these statements were constitutional, whether these should have been admitted, but then not making that argument. But
I think that the defense to a person felt that those interrogation videos helped Rick Allen.
I do too.
I
I think they did help him.
I do too. Like I mean, when I saw those, it was at that point that I was convinced that he didn't do it. Like really, like truly. When I got to watch, I had always like that was the thing for me. I'm like this dude didn't kill anybody.
Right. And I take it back. This is very important because it's a preamble to the later confession. So it is important that when he was sane and of right mind, he was adamant. So these facts are important for that. What happened to my man? You're muted. So just so you guys know, I'm not looking at the chat. Bob's not looking at the chat. We're both looking at our docs. So
True story. True story. I'm not seeing it.
All right. So start with here because we didn't hear.
Detective Holman then tried to use Allen's depression against him, claiming it was because he had killed 2 little girls. That did not work. Detective Holman even used Allen's wife as an interrogation tool. While Allen was being interrogated, ISP told her that the bullet at the scene matched her husband's gun. When they brought her in to see Allen, he hugged her and he said, quote, "It is going to be all right," end quote. While left alone together, she asked, how his bullet got at the scene. And he repeated what he told Detective Holman, quote, "I'm not going to say something that I did not do, and I can't explain something that I don't understand," end quote. He told her, "I know that no bullet from my gun was connected with any murder in any way, shape, or form." ISP lied to Allen's wife too, telling her that a witness identified Allen. Allen assured her, quote, "They're not going to get away with this," end quote, and told her, quote, "I am sorry. I am sorry you are having to hurt. I am sorry I am having to go through it," end quote. Solitary confinement.
So now this is a second section. So this is how they're breaking up all the statement of facts. So this first, everything that we've heard so far is under what they have as section 1, the warrant. All right. So that's basically everything that we did just now goes to the warrant. Although the facts can be applied to different places, it's the easiest way to kind of to line it up because it gives the court the whole kind of history up to that point that they got the warrant. So now we're turning to Westville. Do you want me to take over so you can have a little break with your throat?
I'd love that.
All right. And then you can look at the chat and see if we need to pause to answer a question or, Okay. So A, solitary confinement. And again, this is all under the section for Westville. Just days after 50-year-old Allen was arrested for the first time in his life, he was sent to IDOC as a safekeeper. IDOC transferred him to the Westville Correctional Unit, a maximum security segregation unit for the, quote, worst of the worst. The movies refer to it as the hole, used mostly to punish. Allen was the first safekeeper in any IDOC employee's memory to be placed at Westville. Pretrial safekeepers with mental health issues are usually placed in a mental health unit. The IDOC knew Allen had major depressive disorder and was hospitalized in 2019 for suicidal ideation. He received a D mental health code, the second most severe. So that's a labeling system that they give you when they evaluate you going into IDOC. So he received a D mental health code, the most severe, entitling him to 1 out-of-cell psychologist visit weekly. During the visits, Allen was shackled and confined in a 3-by-3 foot cage separated from the psychologist. And yes, you heard that correctly. For those of you who might not know this much detail. So he's taken out. They're like, oh, he needs to get out once a day. He needs to meet with a psychologist. He is sitting in a cage while he's talking to the psychologist. Allen had no face-to-face interactions unless shackled or separated by bars. Outside his cell, he was restrained with leg irons, handcuffs, and belly chains on a lead. Other Westville inmates in general population lived in dorms, played games, ate together, watched TV, and moved freely. Allen was placed in a quote strip cell, stripped of everything but the bare necessities. Allen's cell was 8 by 4 times 12 by 12 by point 0.5 with a camera, a mattress on a concrete slab, and a bug infestation. His only view was a narrow window facing a razor wire fence. Meals were placed through a door slot. He ate alone on the floor or bed. Allen was recorded 24/7 with, quote, suicide companions outside his cell door, writing down his statements and behavior. Okay, sorry. I can't tell if that's the site or they've just started a new sentence without a period. Okay, so they did. Writing down his statements and behavior, and guards with video cameras filming his showers, movements outside the cell, and attorney meetings. IDOC knew solitary confinement could worsen Allen's MDD. That's his diagnosis, major depressive disorder. Yep. And even cause psychosis. And their policy restricts the time inmates with serious mental illness can stay in solitary to 30 days. But IDOC did not apply that policy to Allen, and he remained in the most secure solitary cell in Westville for 13 months. B. Allen's decompensation. On arrival at Westville in November of 2022, Allen appeared like a, quote, deer in headlights, close quote, but was coherent, quiet, and weighed 180 pounds. By April of 2023, he weighed 135 pounds, was psychotic, and gravely disabled. Early in custody, Allen maintained innocence and believed solitary was meant to, quote, tear him down. He told the psychologist, Dr. Walla, he felt like a, quote, broken man after 2 weeks. Allen described a quiet, normal life previously. Allen was extremely devoted to his wife. On November 14th, 2022, he emotionally told her, quote, if this becomes too much for you, call the detectives and I will tell them whatever they want to know. By January 26th of 2023, Allen was expressing paranoia. In late March and early April, around the time Allen received his discovery and met with his attorneys, Allen's behavior suddenly worsened. Guards thought he was, quote, acting up. All right, so I don't know about this, limiting the time frame and tying the suddenly worsening behavior to his discovery and meeting with his lawyer. That's sort of been what I saw as like a false narrative before, and I thought we had gone through this time frame. Let's mark this as when we get
Michael on.
No, when we get Andy back.
Yeah.
As an Ask Andy. All right. So, because I did think that we discussed this, and there was a lot more. Maybe they get into some more detail about that, or I don't know, maybe it's accurate. Maybe late March and early April, around the time he received his discovery and met with his lawyers, his behavior suddenly worsened. He refused meals, became nonsensical, spoke of, quote, old bear claw, close quote, hypnotizing him, and acted like he was from medieval times. He ripped legal mail, washed his face in the toilet, and drank toilet water. He's there's my East Coast accent coming out. By the way, I worked very hard to change water to water.
Yes, you did.
It was a lot of work. he stuck a spork into his genitalia and covered himself in feces, spit, and vomit. Video from early April showed Alan frightened, extremely thin, bleeding, shaking, contorting, and interacting with non-existent stimuli. He was pacing back and forth, eating his Bible and hitting his head on the cell door. On a video from April 12th, he was naked while he flapped his hands, punched the air, counted imaginary objects, pulled feces from his anus and smeared it onto the food and marched in place. By April 13th, Alan's health had become dire. The IDOC psychiatrist, Dr. Martin, saw him naked, covered in feces, with brown fluid from his mouth from eating it. Ew. Dr. Martin just found him, quote, very psychotic, close quote, hallucinating and incompetent to consent to treatment. On April 14th, the IDOC ordered involuntary medication and found him, quote, gravely disabled, close quote. A working diagnosis of MDD with psychosis. He had lost an abnormal amount of weight and was not sleeping. Haldol produced minimal improvement. He continued to speak in loose associations about things like nuclear war, poisoning, dying, losing reality, cryogenic eyeballs, and not remembering confessions he had already given.
Cryogenic.
And not remembering confessions he had already given. What's that about?
I don't know.
He also continued to play with his feces. After letting Alan sit in his feces for 2 hours on April 23rd, he was removed from his cell and given a shower. After letting him. Yeah, they're like, well, he's just going to have to sit there for a while with that. Alan's symptoms continued through May. On May 3rd, Dr. Walla diagnosed Alan with a brief psychotic disorder, noting that he had disorganized speech and behavior, but no delusions or hallucinations. On May 25th, his shot was still not working. That's the halogen shot. Alan paced for 2 hours and banged the back and front of his head on the metal door for about an hour. Despite his self-injury and a visible goose egg on his head, no one checked on him. The next day, Alan had 2 black eyes from banging his head, and on June 5th, IDOC administered another 30-day involuntary emergent Haldol injection. Ugh. Totally need water.
I'll grab you some.
All right, thanks, babe. Okay, wait. So that was in May, and then that was in June 5th, and then another on June 16th. So on June 5th, he got a 30-day injection. But some reason on June 16th, he got another one. Should have lasted 30 days. Sorry, give me 1 second. Okay. On June 20th, 2023, Alan was catatonic and extremely skinny. Guards carried him to the infirmary, strapped in a chair. After his visit, he remained vacant while staff wiped drool from his mouth. The same day, Dr. Martin claimed Alan was coherent, oriented, not psychotic, and had been free of psychosis for 7 weeks, returning to a baseline on May 2nd. So let's just think about this, all of this, okay? So he's catatonic. He's extremely skinny. Now they've given him Haldol twice in 1 month, okay? They gave him one on June 5th and again on June 16th. But on June 20th, Dr. Martin claimed Allen was coherent, oriented, not psychotic, and had been free of psychosis for 7 weeks, returning to baseline on May 2nd. How in the hell are you giving him forced Haldol twice in a month in 2 weeks if he was perfectly fine? He wasn't psychotic and he was fine. Now, again, like I mentioned before, this is just a statement of fact. So they're not supposed to be making any argument here. Like, oh, see, this is bullshit, like we're doing, discussing it. You can kind of sometimes draft the statement of facts in a way that says it without you coming off as argumentative, as you're making an argument. I mean, not argumentative in the sense that you argue with someone, but that you're putting forth your, what these facts mean or what it shows. It's just supposed to be facts, and it's kind of just an art at the way you draft them to, basically give argument without giving argument. But right here, judges read this and they're like, ridiculous. What? How does she say he's coherent, oriented, and not psychotic after they just gave him 2 shots of Haldol in June?
Yeah, and Rosie got him to recant on the stand.
Oh no, the male doctor said he was, but not Walla.
No,
This is about Walla. Oh, Martin.
Dr. Martin.
Oh yeah.
Yeah.
Yeah. Okay. C. Allen's confession. 1. Allen's family. Allen confessed to his family over the phone April 3rd, May 10th, May 17th, June 5th, and June 11th. I kind of hate that, like he confessed to his family. I don't know. Allen's statements to his family were used as confessions. But
I mean, I look, I mean, they're taking it head on, like they're not going to try to, I mean, in my estimation, they're not going to try to couch it gently. I mean, this is what the state's contention is.
Right.
So, they're taking it head on. We'll see what they say.
On May 3rd, he told his wife, quote, "I did it. I killed Abby and Libby," close quote. Later saying, quote, "Maybe I did it. I think I did it." On May 17th, 2023, Allen insisted to his mother he killed the girls. The next day, on May 18th, Allen banged his head against the cell door to the point he had a gash. On June 5th and 11th, Allen told his wife he did it, but that he has lost his mind. He is probably going to kill himself, feels like he's already in hell, and does not understand what is happening. 2. The guards. From April through June, guards repeatedly heard Allen confess, "I killed Abby and Libby," close quote, amidst bizarre behavior. His statements occurred while he smeared feces, rolled in it, drank toilet water, shouted at his shadow, sang, masturbated, paced, saluted, asked nonsensical questions, hit his head, and asked if he was dead. On April 29th, Allen made more specific statement to a guard, claiming he killed 2 girls in Delphi with a box cutter that he stole from and left in the trash at CVS. He was going to them, but he panicked and killed them. He said they were screaming. Just the day before, he was covered in feces.
No mention of the van.
That was to Walla, wasn't it?
This
is to guards. These are just guard.
Oh,
these are just statements to guards. Now, here we go.
Wait,
3.
When
Dr.
are they
Walla.
claiming? Well, I'm so confused. When did he allegedly make that statement to a guard? I don't remember that. I don't remember there being a detailed second confession to a guard.
Well, I remember a box cutter statement, but they weren't There was no
I thought
evidence
that
that they
was
were
all
killed with a
to. I thought that was all to Walla, but
apparently not.
apparently
All
not.
right. Or maybe he did that as well. We're about to see. Dr. Walla. On April 5th, Alan's emotions shifted rapidly. He questioned whether he was God. He slipped a sheet under the door, wanting to confess to the warden. Later, Alan told Dr. Walla, quote, I killed Abby and Libby. I'm sorry. He had intense eye contact, bizarre smiling, and circumstantial thought. Although he would go off on a tangent and sometimes never return to the original topic, Dr. Walla claimed his confession was concise. So there's a way you can see argument, crafted in a fact. Although he would go off on a tangent and sometimes never return to the original topic, Dr. Walla claimed his confession was concise. Alan said he was motivated by sex, but was uncertain whether he had sex with the girls. Alan also confessed to molesting his sister and daughter, claims contradicted by them. Did the daughter testify?
Yes.
Oh, okay. Did the sister?
I think so. Yeah, I think they both testified.
All right. Well, there's a quote to their trial transcript. So 2 days later, Alan asked Dr. Walla if he had confessed. On May 2nd, Alan was very tangential, repeating himself and jumping between topics. He said, quote, I killed Abby and Libby. I will kill everyone. I will wipe out the whole world after I die, close quote. He mentioned World War III, was confusing nightmares and reality, thought he must have schizophrenia, was randomly saying methamphetamine, and telling people, including Dr. Walla, he loved them. The day before, Dr. Walla was unable to have a meaningful conversation with him. May 2nd, he returned to his baseline. May 2nd. That's what she said earlier. That's what Martin said, I guess. On May 3rd, he confessed to following the girls to the bridge when the bullet fell out, and then he said, down the hill. Come the fuck on. Exactly what's on this is everything that they know. Oh, Lord. He was going to R them, but saw a van. So that's what you're talking about.
Mm.
He crossed the creek, slit their throats, and covered their bodies with tree branches. He also said he feared missing Easter, though his interaction with Dr. Walla. What?
Thought.
He said he feared missing Easter. Oh, thought his interactions with Dr. Walla were fake and was paranoid about his safety. After entering a summary into Alan's record, Dr. Walla destroyed her notes. Thank you, Dr. Walla. On May 10th, with Dr. Walla present, Alan told his wife, I did this. I killed Abby and Libby, while also insisting he was losing his mind. He continued believing he was dead, that the world would blow up if he fell asleep, that water was poisoned, and that he was reliving the same day. Dr. Walla listened to podcasts about Alan 3 hours a day while commuting to work. Wow, they really wanted to save that. I mean, isn't that slash still a letter? Before Alan was arrested, she researched a suspect on IDOC's database, and after she treated Alan, she posted on social media about his case. All right, new section. You want to do the new section? You want me to keep going?
I'll do it. Witnesses in trial. Let me see. Okay, section 3, witnesses in trial. Beginning October 17th of 2024, the state tried Alan on 2 counts of murder and 2 counts of felony murder. During the 25-day trial, the state built its case against Alan on 7 points. A, what the jury heard. 1, bridge guy. The jury saw the video of Bridge Guy on LG's phone. They also heard from 2 of the 4 girls, RV and BW, Blair and Carbaugh. After seeing the video, the witnesses believe they saw Bridge Guy on February 13th, 2017. Blair thought she saw him on the platform of the bridge. She described the man as white, possibly in his 20s or 30s, with brown poofy hair and a youthful or boyish appearance. She also believes that she saw AW and LG approaching the bridge while the man was still on it. Blair's Fitbit data placed her near the bridge at the time of LG's video. Although Carbaugh in 2017 reported seeing a muddy man in a tan coat at about 4 p.m. walking west on 300 North toward town, by trial, she claimed that the man was muddy and bloody and wearing a blue jacket. Also, surveillance video captured a car like Allen's driving down 300 North at 1:27 p.m. Prosecutor argued that this was Allen shortly before he parked and walked to the trail, and that Carbaugh saw Allen walking back to his car after committing the murders. At trial, no eyewitness identified Allen as Bridge Guy. The prosecutor, however, told the jury that Allen must be Bridge Guy because every eyewitness is adamant the person they saw on the bridge was Bridge Guy, or the person they saw was Bridge Guy.
So,
Quote,
go ahead. Sorry.
No, what were you going to say?
No, I want to wait till you finish that quote.
Quote, there's no doubt in their mind. End quote.
All right. So let's just think about that. So what are they adamant about? The person they saw is Bridge Guy. No doubt in their mind. It says nothing about Allen.
Right.
Nothing about Allen.
And the funny thing is the one juror who talked publicly, like that was the thing. She's like, oh yeah, they proved to me that Allen was Bridge Guy. I'm like, when?
I mean,
so, and Blair, according to the prosecutor, must have seen Allen right before the girls because Allen told us, quote, he went onto the Monon High Bridge out to the first platform, which is, quote, exactly what Betsy Blair told you. Trooper Harshman, who had listened to Allen's jail calls, believed it was Allen's voice on the video. That was an insane moment at the trial.
right, but
The jury heard from a battle of firearm experts over the bullet.
Wait, I just want to pause right there because at least I don't think that this is in, and maybe it'll be, and maybe it'll be something that is somehow encompassed in one of the errors, but to me, this should have been an error that he was able to identify Allen's voice on the video. I think they should have argued that video, the audio that was played at trial, was too altered by way of trying to improve it to identify anybody's voice. I wish that was an argument that be made, but maybe it's an argument that can get made still on and not be considered waive on post-conviction, because what we don't have in this record is any evidence about how the sound of one's voice can change by the altering of it, and I don't know. Is the unaltered version, I believe the original version is somewhere in the record, but if it's not, then that will help this be an issue that might still be able to be brought up in a post-conviction petition, because just so you guys know, if it's not raised here, you cannot raise it again unless it's outside of the record, unless it's new evidence or something outside of the record. All errors, trial errors, have to be raised in your initial brief. So I think it was something that should have been raised personally.
Yeah. I mean, it was a shocking moment in the trial. Anybody claiming that because they listened to Allen's phone calls can then match somebody saying 3 words on a fucking video
that's been enhanced, edited, altered,
or not altered. Either way, I'm with you 100% on that. But 3 words, fuck out of here, dude. Sounds like whatever.
You're right. Even just based on that and 3 words, the judge should have excluded it as unreliable, more prejudicial than probative. Just completely ridiculous.
Yeah.
but it's not an issue that, as it appears thus far, it's not an issue that was
And
raised.
that was a mic drop moment for like I believe that was the last question that McClellan asked Harshman. Like that's what he ended his direct on. All right, 2, bullet. The jury heard from a battle of firearm experts over the bullet. For the state, Oberg testified that when she matched test firings from Allen's gun, the unspent casings at the murder scene, she applied the Association of Firearm and Toolmark Examiners methodology. She gave an error rate for the methodology of 2.2 for false positives and 2.87 for false negatives. She discussed studies and articles that she reviewed to apply the methodology. Oberg admitted that the AFT methodology is subjective, but she testified that in 17 years of applying it, she was unaware of ever making a mistake in identification. During closing, the prosecutor told the jurors that she has, quote, never been wrong.
All right, so
End quote.
you could raise an issue about this, that that there was some sort of error or prosecutorial misconduct, that they said this, because you don't know you're wrong unless somebody finds out you're wrong. But they're putting it in here, and it's not part of the actual appeal. So I'm interested to see what maybe Michael thinks about why that's even included.
So for the defense, Eric Warren, an expert in applying the AFT methodology, testified that comparing tool marks on an unspent cartridge with tool marks on a spent cartridge, I'm assuming they want to put in there, on a spent test firings, a few typos, with tool marks on the spent test firings is akin to comparing apples to oranges. And in his opinion, there was insufficient agreement on the tool marks to match Allen's gun with the unspent casing found at the murder scene.
All right, give me
The
1
third-
second, babe. Sorry, because I earlier told everybody that Tobin Okay, so that is accurate. All right, sorry. That Tobin was that expert, but he also that wasn't allowed in. Okay, so
right.
wait, I got to get back to where we were. What page are we on? I think I got
33.
Yep, got it.
The third thing that the state relied on, the timeline. So Christopher Cecil testified regarding the movement and health data on LG's phone. The girls encountered Bridge Guy at 2:13 p.m. and LG's phone stopped registering movement at 2:32 p.m. He summarized the movement data as follows. From 1:31:40 p.m. to 2:08:48 p.m., 1,682 steps were walked. From 2:08:48 to 2:12:48 p.m., 414.38 meters were walked. From 2:52:22 to 2:32:39 p.m., 2 flights climbed and final movement recorded. The state argued that this activity overlapped with Allen being on the trails and Allen completing the murders and leaving the scene by 3:56, where he was seen by Carbaugh walking on 300 North.
All right, so that's my first question here. So they say final movement recorded 2:32 p.m.
Mm-hmm.
And that is consistent with him leaving the scene an hour and a half later. An hour and a half later to put a couple of twigs.
He was hanging out. He was making sure he got Abby's hands real clean somehow. Had to make sure he didn't leave any DNA on the scene. All those things. Somehow he did all that in 17 minutes, 19 minutes, whatever the hell it is. It's outrageous. Allen contested this timeline through Stacey Eldridge, a former FBI forensic analyst. She testified that someone inserted wired headphones or an aux cable into LG's phone at 5:45 p.m. and removed it at 10:32 p.m. This would silence the phone. And she noted that an incoming phone call occurred moments before the headphone or aux cable were plugged into the phone, which would have silenced the call. In response to Eldridge's testimony, the state asked Cecil whether water damage could be responsible for Eldridge's findings. Over a hearsay objection, Cecil testified, quote, that he Googled it during the trial and found some unspecified, non-peer-reviewed, quote, troubleshooting forums reporting that water damage or dirt within the phone socket could mimic headphones being inserted. Case closed. Good day, sir.
I do believe that this is a very strong appellate issue. It's pretty serious.
It's pretty serious. Confessed motive. The fourth thing the state relied on. When the state arrested Allen, it had, quote, no explanation for the murders. However, the state argued that once placed in solitary, Allen confessed to the crime and a motive. While gravely disabled, Allen confessed to guards, Dr. Walla, and his family. On May 3rd of 2023, he told Walla that he was going to R these girls, but panicked and killed them. He said they were screaming. The prosecutors argued that the jury should believe Allen's confessions, despite his psychosis, relying on the opinions of Dr. Walla, the great Dr. Walla. The guards and Trooper Harshman, who reviewed Allen's videos and calls. The prosecutor claimed that Allen's confessions were logical and organized, and that the product of free will and his newly found religion. I found God. Almost every guard testified Allen's bizarre behavior was, quote, orchestrated, end quote, and not the product of mental illness. One guard said he knew Allen was truthful in his confessions because of, quote, the look in his eye, end quote. Some guards claimed inmates commonly smear or eat feces as a, quote, tool for attention. None are mental health professionals or knew Allen's mental health code. Each time that Allen confessed to Dr. Walla, she said he was not delusional, hallucinating, or psychotic. And that's April 5th, 3rd, May 3rd, May 10th. Although Allen expressed confusion and memory gaps, she suspected he was feigning or acting bizarrely. On cross, she admitted she may have been wrong, and Allen might have been genuine. With hindsight, she was, quote, on the fence. The state introduced 31 suicide observation reports containing Dr. Walla's opinions. Except for a few, she continued to find Allen non-psychotic while documenting paranoia, delusional thoughts, confusion about being dead, and self-injury. She at times labeled him as feigning for secondary gain. The day before he was deemed, quote, gravely disabled, end quote, she wrote that he could be exaggerating or consciously deteriorating. When he ate feces, she called the behavior, quote, unclear. Dr. Martin believed Allen was psychotic but in remission after a mid-April Haldol shot and back to baseline by May 2nd. Like Dr. Walla, he described psychotic symptoms, yet concluded Allen was, quote, much improved. When either doctor acknowledged psychosis, they attributed it to factors other than solitary. Regarding Allen's phone call confessions, Trooper Harshman said Allen's demeanor was calm and solemn, and he was not under duress or stress. He opined that Allen acted this way for attention. Allen called Dr. Westcott, a neuropsychologist, who opined that Allen entered IDOC with MDD and physically and mentally decompensated, showing early signs by December and March, becoming psychotic April through June with residual symptoms later. Allen's solitary confinement, sleep loss, and starvation produced sensory deprivation, delirium, or psychosis. Dr. Westcott believed Allen was psychotic or delirious when confessing to Dr. Walla. After reviewing all records and videos and evaluating Allen for days, she found no evidence of malingering.
Hey, babe,
Yo,
can you pause a second? Because I need 2 minutes. Talk about something else.
I can just pull it up.
No.
Is that cool? Let me move it to the screen over here. Okay, let me see here. I'll pull Allie's down. Okay, let me see if I can find it. Is this where I'm at? Okay. Does it work? I'm in the wrong spot, Joe. Let me see. Is that right? I'm on the wrong page, but whatever. I'll catch up. I'll find it. Okay. This is the one that I want. Dang it. Sorry, guys. Hold on. Hold on. Please hold. At this point, she'll be back. Let me see. Let me pull down the old prosecutor from Holly Bobo. She's pleasant to look at. Yeah, if you guys are not aware of that Holly Bobo case with Zach Adams, I want to take a peek at that one because it's crazy. It's crazy. All right, let's see here. What the hell's going on? All right, bear with me. Bear with me. I'll get there. I'll
Do you need
get there.
me?
Oh no, you're back. All right. I was struggle busing trying to find it.
Do you want me to just stick it back up where it was?
Yeah, put it back up. I just couldn't find it for the love of God.
I thought you
I really
were.
tried. Is that yours?
Yeah.
Excuse me. All right, let me get back to mine.
So we were on page 36.
Yep, I'm with you. I was getting to Dr. Grassian. All right, so Dr. Grassian, a psychiatrist experienced with solitary confinement cases, testified that such environments cause psychotic delirium, confusion, and disorientation. Delirious behavior often becomes grotesquely regressive, including smearing feces, sexual acting out, self-harm, and suicide. On recovery, memory is often absent. He had, quote, no doubt Allen was delirious and saw signs of false memory common in delirium, where a belief evolves into a perceived recollection. Some people will say, quote, I think I did it, end quote, and after time start perceptualizing the event. The more someone tries to remember, the more concrete and distorted the, quote, memory becomes, like a game of telephone. The fifth thing they relied on, a detail only the killer would know.
Now, not to like pick on how you're saying it, but I guess it's because it's like the fifth section of their statement of facts.
No,
So,
this is one of the 7 things that the state relied on to get the conviction.
oh. So in the statement of facts, they said there's 7 things. Okay, gotcha. Thank you.
You're good, baby.
I was like, why is he saying it like that? Gotcha. Okay, so in the statement of facts, they're giving this how many things? 6 or 7?
I think they said 7. The
All
7
right.
things. 7
Okay.
things. A detail only the killer would know. So Brad Weber, who lives near where the girls were found, told the jury that he worked in Lafayette. And at around 2:02 p.m., he drove his white cargo truck directly home, arriving around 2:22 to 2:27 p.m. The state claimed that Allen confessed to Dr. Walla that he had attempted to R the girls, but was scared after seeing a van, which forced him to flee with the girls across the creek. Allen's statement, the state told the jury, contained, quote, a detail only the killer would know, end quote. The state argued that Weber's arrival home in his van was what interrupted Allen, causing him to take LG and AW across Deer Creek to kill them. 6, the murder scene. The murder scene was unusual and complex. LG was naked, and AW was wearing LG's clothes. AW's right leg was positioned underneath her left. Both girls' throats were cut with a sharp instrument. However, the injuries were different. LG had so many incised wounds along her neck that it was difficult to determine the number. 3 major vessels were injured.
Oh.
There was a scalloped edge along an incision. AW's throat was only cut once and not as deeply as LG's throat. AW was likely murdered while wearing LG's clothes. AW died in the location where she was found, but after LG died, her 200-pound body was moved several yards to its final resting place. This created a V formation with the girls' bodies.
You want to talk about that chart a little there? Who's who? What's what?
So obviously Abby is the clothed person there. And as you can see, her leg is tucked under. And then Libby is here with a very large limb laid on her arm. And as you can see, obviously she is nude. You can see that there is blood indicated on both of her hands and around her neck. Here you can't see Abby's hands, but I'm here to tell you her hands were near flawlessly clean.
I felt they looked washed personally.
Yeah.
And I want to note, let's just look. So you've got this long branch here over the arm. You've got a thinner one here over the arm in the, like exact same spot. And then you have like this crisscross thing. And then here you also have a crisscross thing. I don't know.
All right. Well, I mean, the bottom line is you can see maybe a total on Abby of 1, 2, 3. Looks like 3 sticks. On Libby, you've got the large limb. You've got 1, 2, 3, 4, maybe 5 sticks. The concept that they tried to put forth at trial that this was an undoing, that he was trying to, killer's trying to, undo the horrible thing that he had just done, or that they were just killers just trying to cover the girls,
right?
Hide the girls. I mean, you guys have eyeballs. Does that look like somebody trying to hide a body? Because that's exactly what the scene looked like.
And how in the hell is putting sticks on someone and undoing? This is how I take it all back.
You're asking the wrong guy. I have no idea. So the sticks were deliberately arranged on the girls, covering no more than 3% of their bodies, which came in through their guy. Ajay got him pinned down. It would have taken up to 20 minutes for AW to die. To die. Although Liberty's injuries were more significant, it would have taken her between 5 and 10 minutes to die. And that's through blood loss, obviously. The blood pattern on AW's hands was noteworthy. When injured, people instinctively reach for major wounds, getting blood on their hands and sleeves. Libby had substantial blood on her hands, but Abby had little to no blood on her hands or sleeves. The state's blood splatter expert had, quote, never seen clean hands and sleeves in a case involving this much blood loss. The absence of blood may be consistent with unconsciousness or restraint, but there were no defensive wounds, bruising, blunt force trauma, or ligature marks on either girl. The bodies were lying in the prone position, yet both girls' faces had blood patterns flowing upward against gravity and over their chin and face. Thus, sometime during the murders, a person articulated the girls' torsos and necks above their chins. Remember that big debate you and I had that one time about what we were trying to say? Like I was trying to talk about how like like you weren't getting it, but I was like, if somebody's got somebody by their legs and they're dragging the head, that would have created the blood flow going up because the legs are above the head. The body would have been like this. Like for some reason,
I think I was trying to say, like, if you're pulling someone's legs, that you're usually not actually lifting anything more than their legs, not their butt
maybe
and not their torsos.
not a dude. Like if I'm like you're assuming that somebody's just like dragging like their legs
Right.
like on the ground. That's not how I drag shit. Like if I'm dragging something, I'm picking the legs up and I'm pulling. You know what I mean?
I guess you're
Like
saying so you get, like, put the legs kinda behind you, get real
no,
up.
dude. I'm just standing up straight. I'm lifting the legs to where my arms like like are laying naturally. Like if
You're
I'm
talking to a
standing,
short person.
right,
My arms
and
aren't
like,
doing all
and
that.
I would think that maybe if you were the killer, that you would have dragged her like bending over, just like pulling, like For me, if I'm like dragging anything, I'm going to be in an upward position and lifting up.
But it would be he's small, right? And
Yeah,
it's still hard to get even if you got those legs up, you're getting the butt up off the ground and then the torso up off the ground. I mean, it to me still seems hard. I don't know. I'm gonna have to lay somebody down on the ground and make you
I'm
pick
gonna
them up
lay
like
you
that and
down on the
drag them.
ground and I'll
I'm not
drag you around.
draggable right now with my arm.
You could drag me around. Like like you wouldn't probably would not be able to well, definitely with your injury, but like even healthy, like I don't know that if you were to try to drag me that
Oh, I'll drag you, buddy.
yeah, no.
I don't know that I'd get very
I
far
mean,
through.
like, so I guess that would make sense for like for your purposes in terms of like kind of bending over at the waist and like just pulling
Right.
as opposed to like a bigger guy, like that would be dragging somebody would like just grab the legs, stand up and pull,
Right.
like
But
from
he's
a
kinda short.
especially if you're manipulate well, Alan didn't do it. So okay. So you've got the manipulation of the body as well. Because remember, like if you go back to the diagram real quick, because it's always been my contention. And the interesting thing is that there were no drag marks found.
I thought there was some by
I
oh, maybe not, I don't
I don't
remember.
think like I thought that there were no drag marks that I heard at the 3 days of hearings, and then I thought that maybe somebody at trial tested. Well, hopefully they get to it in here. But all right, so look at the large collection of blood here that has the sticks on it.
Mhm.
Like was somebody trying to hide that blood stain and they put some sticks on there too?
Right. That
So
they're concealing that blood stain.
but like for there not to be any significant drag marks, I mean, what that tells me, like where you're pulling, so what that says to me is that Libby's feet were at one point facing the opposite direction and that Libby's head was here and that she bled out here. And then when she's dragged, her entire body
Oh, sorry.
is turned so that her feet are facing the opposite way of where she was lying down there. Because otherwise, she would have been dragged through the blood by her arms.
Right, or she was hung upside down, or there were 2 people, like, we're saying that this is a two-person crime.
Right. I mean, all of this to say that one dude didn't do this, and it sure the fuck wasn't Richard Allen. So it would have taken up to 20 minutes for AW to die, although LG's injuries were more significant. It would have taken her between 5 to 10 minutes to die.
We were
Oh yeah, we're beyond that. Okay, so LG had substantial blood on her hands, had little to no blood on her hands or sleeves. Oh yeah, we're past all that too,
yeah,
right?
go to page 40, right after the girls' torsos and necks above their chins.
Okay. So the next paragraph,
Yeah.
it was clear that someone, quote, lifted LG's body to create the flow pattern. AW had a similar pattern, which meant her body was also articulated to a position where her neck was higher than her chin. So this occurred while AW was wearing LG's clothes.
Yeah, let's go back to this. How are you getting in your scenario
If
where
if
a
I
tall
if you were not
person,
injured, I would demonstrate it right now exactly what I'm talking
I
about.
could see that on Abby, but what about Libby? How is someone lifting one person lifting her body, her neck above her chin?
That's what I'm trying to tell you, babe. It's like you're I'm not talking about like if you're at this angle, like if I've just lifted your legs, honey,
Mhm.
okay, and your head's down there and your legs are up here, that gravity, the blood's going to be flowing up. Your chin is going to be above your face and your head.
Well, you've got somebody
You're having a
way off
hard
the ground, though.
No, I don't. Do you want me to come down and just like demonstrate? Like we won't mess with your arm. Should I
No,
get my I'll
we'll
get
do
my
it later.
dad I'll get my dad to lay on the ground.
Yeah.
See, it would be perfect if Scout were here. Like Scout would be a
Oh,
very
but she's super light.
she's probably about same weight
As
as
Libby?
no, as Abby.
Right, but this happened to Abby and Libby.
I understand.
All right, let's
I'm
move
just
on.
saying, like, I'm gonna be able to drag, whatever Abby's weight is in 200 pounds, 5 feet. But in order to articulate it in a way where that's what I'm saying, like either she's lifted so as not to leave drag, like there's no evidence
Right,
that
or her
I
head
don't
was
think
downhill before and they moved her around, is what
right
you're saying. Right.
facing the opposite direction, which means that they swung her body around
Which
and
means they
positioned her
wanted her specifically
for whatever
pointed in
right,
a certain that direction made a difference to this killer.
right.
The position of the body made a difference to the killer. All those things. Yep. I hear you.
Okay, so about 4 feet off the ground, there was a notable blood pattern on the tree in LG's blood. So here's the infamous F tree, which
That's the best picture we've ever seen.
yeah, it's pretty clear.
Surely looks like an F there. You cannot tell me that's somebody's hand.
Or spatter. Or
Right.
yeah, so yeah, like there were arguments initially that it could be spatter, and then it moved to be it was Libby had placed her bloody hand on the tree, while she was slumping down to her final resting place. So that doesn't look like that to me, but I'm no blood expert. What do I know? I don't know anything. So the state performed a SA kit on both girls and found no physical evidence of SA. Despite testing the SA kit, hundreds of clippings from the clothing and swabs from the girls' bodies, cartridge, and cell phone, law enforcement found no DNA from Allen. It's amazing. That's amazing. What a amazing amount of work he finished in 17 minutes. The state told the jury that Allen controlled the girls, swapped AW's clothes, articulated their bodies, and moved LG all by himself before fleeing the scene by 4 p.m. The state's witnesses repeatedly claimed that Allen used the sticks as camouflage and that he moved LG's body to make it harder to see. This, the state argued, caused blood to flow over LG's chin. And for reasons the state could not explain, Allen dressed AW in LG's clothes and turned and repositioned her at the scene, causing blood to flow from her neck and over her chin. Although the girl's injuries were different and possibly caused by multiple weapons or, quote, different mechanisms, end quote, altogether, the state's pathologist, quote, speculated that a single blade, such as a box cutter, caused all the injuries, including the scallop mark. The blood stain on the tree, according to the state, was an inverted L, transferred from LG's arm as she was propped up against the tree. In a female hair and multiple incomplete profiles were seen contamination or, quote, background DNA from the girls sharing clothes or through incidental contact with people that they knew. According to the state, it could not find Allen's DNA because the blood from AWNLG was overwhelming the scene and, quote, competing with any DNA that Allen left behind. Do you like that theory, babe?
It's wonderful.
It's a pretty good theory.
Now everybody knows how to get away with the crime.
Pretty scientific. And then 7, the manner, quality, and thoroughness of the investigation. I can hear the sarcasm in that. At trial, the jury heard about the state's investigation from the day the girls went missing to a few days later when Allen met with Doolin, who was the resource officer. The state then told the jury to fast forward 5.5 years to the volunteer finding Doolin's report. Good old Kathy Shank. Doolin's report in September of 2022. The jury heard nothing, maybe very little, regarding the manner, quality, and thoroughness of the investigation between the murders in February of 2017 and Allen's arrest in 2022. So, on November 11th, 2024, following a 25-day jury trial, the jury found Allen guilty on 2 counts of murder. Allen appeals. Below is the evidence the defense was prohibited from offering to the jury.
Wait a second.
Hold
That's
on
7.
1 minute.
And this is B. What the hell is 2? It's like they broke and got to it like a different section of the brief. They were in the middle of the,
What do you mean?
I don't know.
So this A was
3 is witness in trial A.
Right, witness and trial. A, what the jury heard.
Right.
So, and this is where it says the state built its case against Allen on 7 points.
Right. So
We just
here's the
went
7
through.
points.
Correct. And now B, this is what they didn't hear.
Right. But then why does it say, right? Like, what's this random sentence about on November 11th, following a 25-day trial, jury found him guilty? I think they just, okay, yeah, I get you.
Wait.
No, you're right. I'm sorry.
What
So this is what they heard. And so following a trial, they found him guilty, and now this is what they didn't hear. I get it now.
I think
Sorry.
it was for effect.
Yeah,
So,
yeah.
Here's what they put on, and then 25 days, they convict him. We're now appealing, and below is the evidence.
I get it.
I like it. I don't hate it.
I like it too. I like it too. I was just confused.
Confused. You ready? You gonna do that? You gonna do B?
Okay. B. What the jury did not hear. 1, bridge guy. The jury never saw the sketch below, which is the man Blair saw on the bridge when Abby and Libby were approaching. The sketch does not look like Allen, who in February of 2016 was short, 44 years old, with closely cropped hair. Blair rated the sketch 10 out of 10 for accuracy. In 2017, Blair rated the sketch 10 out of 10 for accuracy. In 2019, she reaffirmed her confidence in the sketch and insisted that she could identify Bridge Guy if she saw him again.
Like in court? I mean, Richard was sitting right there, feet away.
Yeah. Man,
oh man.
We just went right from waking up till it's 3:43. No food, no break.
Oh, not enough hours in the day, baby. It's not enough hours in the day.
Nor did the jury hear that Blair, and at one point the ISP, believed the man she saw, Bridge Guy, was not the man Carball saw, muddy and bloody. And they cite to this exhibit and they quote, "I think it's wrong." So that's a point in time where Blair said that, and the jury never got to hear that. 2, the bullet. The jury never heard that the firearm and tool mark evidence is flawed and unscientific. Allen proffered expert witness William Tobin to explain the scientific community's criticism of the AFTE methodology. Tobin is a nationally recognized forensic metallurgist. Wait. Yeah?
Sure.
Metallurger. Why? Metallurgist. Oh my God. Yeah. Metallurgist.
Just you should know how to pronounce this from Oh Brother.
I know.
Just metallurgist. I mean,
Metallurgist.
yeah.
Yeah.
You're right there.
Metallurgist.
You're
What
right
was I saying?
there.
Metallurgist?
Yeah,
Metallurgist.
It was adorable, whatever it was.
Oh boy. He has extensive experience in metallurgery.
Any of you boys trained in the arts of metallurgy? Or otherwise trained, any boys Smitties or otherwise trained in the metallurgical arts is what it was. Yes.
Yeah, metallurgical. That's why I say it that way. Metallurgical.
All
But
right.
it's metallurgy.
Metallurgist.
Metal
Yeah.
metallurgy and metallurgist.
Yeah.
Okay. Bullet
In metallurgical arts.
yeah. Okay. Bullet
Back
and
to the body. Back to the body.
back to the body of the document. Bullet and lead analysis and toolmark principles, along with a background in statistics. He is familiar with the President's Council of Advisors on Science and Technology.
This is why I couldn't remember Tobin. Sorry to interrupt, because like
He was
barred him
excluded.
from testifying.
Right. He has criticized the AFTE methodology of toolmark identification. Tobin reviewed Oberg's work and was prepared to explain the flaws in the AFTE methodology. He has testified in over 297 cases and has been recognized by state high courts as an expert on this topic, including in Virginia, 2025. 3. Confessed motive. The jury never heard Allen's confused, disjointed ramblings and screams during the months that Dr. Wallace said Allen was making logical and organized confessions. The trial court permitted Allen to play 15 videos of him in solitary to impeach his confession, but required Allen to mute them. The excluded audio showed the following. Oh, this is good.
All right.
Wow. Okay.
Now we're getting somewhere.
Wake up, everybody out there. Video 972. Guards extracted a skinny, white-eyed Allen with blood on his forehead.
Wide-eyed.
What?
Wide-eyed.
Wide-eyed.
You said white-eyed.
Oh, wide-eyed. Allen with blood on his forehead. Allen screamed for his dad and asked the guards to hold his hands and yelled, quote, Roger, Marvin, wait for it. On April 13th, guards ordered Allen to cuff up. Naked and confused, he clutched the sink and shook. When officers entered, Allen begged to be put on an airplane and told them not to believe his last confession. On April 17th, while being transported to see Dr. Walla, another inmate yelled, "Kill yourself, Richard Allen." On April 17th, during a transport to a forced injection, Allen screamed, spoke incoherently, asked for his mommy and daddy, and rambled about suicide and time travel, and within 7 minutes claimed to be both the stupidest and smartest person ever, and repeated, "Wait for it." A guard told him the, quote, "games are over," and commented on feces on him. Allen responded tangentially, "Rocky Balboa is my favorite actor. Clap on, clap off." A guard noted the feces, quote, "has been on him for a while." April 21st video. During a haircut, Allen mostly stared into space, confused. He responded, "Leave the top," when asked if he wanted his face shaved. April 28th video. During a shower transport, Allen spoke incoherently, repeatedly saying, quote, "There is a God," quote, "Please don't do this," and, quote, "Make it painless." With feces on his face, he asked to be euthanized and whether his wife was present. He said he was King Michael, claimed he started World War III, tried to save his family and Donald Trump, sang hymns, quoted scripture, and asked to be cryogenically frozen.
Oh, maybe Trump will pardon him.
Maybe. Video from June 20th. Guards carried a catatonic, drooling Allen to the infirmary. The medical professional discussed with Allen his cholesterol and blood pressure rather than his non responsiveness and involuntary jerking. Allen stared blankly when he asked the date or season. Allen asked the court to watch the video with the sound, especially. Okay.
At
With
15:30 and 16:50.
Okay.
So that's
okay. So especially these videos. So sorry.
Right.
So the Allen asked the judge to watch the videos with the sound and specify the video numbers, the same video numbers that they just went through in detail there,
Right.
or much of them.
I don't see 172.
It
No,
might have
there's
supposed to
actually
be 972. I think
yeah.
that's a typo.
Ruh-roh.
Yeah, it's all right. Okay. Also, the jury did not hear Allen, the morning he started confessing, tell his family in 3 intertwined calls that he was confused and losing his mind. In the first call at 3:12 a.m. on April 3rd, Allen told his dad he was losing his mind and was uncertain how much longer he was, quote, going to be lucid. Allen said, quote, "You guys know I would never do something like I've been accused of." Allen felt he had been mentally tortured, like he is in Guantanamo Bay, and that there were drugs in his coffee and Kool-Aid. In the call the jury heard at 4:15 a.m., Allen told his wife for the first time he thinks he killed Abby and Libby, and quote, evidentially did it, close quote. Evidential. Why can't I speak?
Well, because they have a
Spelled
typo
it
there.
wrong. Right. Okay.
Because he says evidently I did it. So just to remind you guys, this is that completeness doctrine argument here, where Allie and I were talking about this last night. So the call that she just discussed was the earlier call to his mom's house, and he's talking to his dad, his stepdad Ken. So that precedes this second call, which is the first time that he ends up saying I did it. And you know, like there's more to this thing. Like you guys have heard that. It was
but
just crushed me.
completeness is never mentioned in here, so they didn't bring up that she erred, which is shocking to me. Okay. All right, evidently did it. Allen could not remember what he told his dad in the earlier call. Then, in a third call at 8:45 a.m., a panicked Allen told his wife he was not sure if his original call to her was a dream. He said he was not drinking the water or the coffee and questioned whether the attorneys who were coming to visit him were his attorneys. The jury only heard the second call with the confession, along with Trooper Harshman's opinion that Allen showed no indication he was under duress or stress when he made that admission. Okay. 4, a detail only the killer would know. Now, they had that same caption when they were talking about evidence they did hear. Now, this is, again, don't forget, evidence the jury didn't hear. The jury never heard that Allen could not have walked the girls across the creek to kill them after seeing a van driving down a lane as he confessed. The state had video showing Weber's van arriving home 25 minutes after the pause in movement of LG's phone and nearly 15 minutes after it stopped moving altogether. Specifically, security camera footage from Weber's neighbor showed him arriving home around 2:44. And the state also had a report prepared by the FBI, which confirmed that Weber's cell phone arrived home around 2:50 p.m.
Man, that's a real timeline killer. That's a real timeline killer.
That's a real timeline problem. What do you think about that?
Killer of the old
hell?
state's timeline.
What the flip?
Attack the
Nah.
timeline.
Nah. Come on now.
Attack the
What?
timeline. Attack it. Got to kill that timeline.
Yep.
Yeah.
The jury also never heard that Allen confessed to details that the real killer would know were wrong, including that Allen said he shot the girls.
Oops.
The judge prohibited Allen's expert, Dr. Gracian, from identifying Allen's signs of being in a state of delirium and hallmarks of a false memory. One such hallmark was the facts Allen got wrong. 5. Allen's alternative exculpatory explanation of the scene. The jury never heard that from the beginning, many investigators believed and investigated the girl's murder as part of a Norse pagan ritual, and that the usual and complex scene had textbook features of such. There was, quote, always a discussion, close quote, among law enforcement that this may be a ritual murder, that the sticks were Nordic runes. Also, many officers believed the scene was too complex for just one person to be involved. Within the first weeks, the Carroll County Sheriff enlisted the FBI's Behavioral Analysis Unit to evaluate whether the sticks related to, quote, pagan rituals. After examining the evidence, the BAU declined to exclude pagan ritual as a plausible explanation for the murder scene. Quote, it remains possible a new believer or rogue believer in Odinism was involved in this case. A Purdue professor also consulted law enforcement on whether the sticks were runically inspired. He found it, quote, quite plausible. Quote, these markings constitute an instruction inspired by Norse runes or modern recreations thereof. Law enforcement consulted with an undercover ISP trooper regarding the sticks and the blood stains on the tree. The officer was familiar with Norse pagan symbols through his covert intelligence, and he agreed the blood on the tree resembled the pagan Fehu rune, and he found similarities between the stick formations on the girls and the pagan bind runes. Once Allen was charged with murder, the defense team consulted a nationally recognized expert, Don Perlmutter, who found 7 features of a Norse pagan ritual. They include, my Lord, I think we need to have a stand-up stretching session. I want to get through because we're only 10 pages till we're done.
You want me to pound those out? I could do the last 10 if you want. If you want to stretch a little.
Okay, yeah, I'm going to stretch a little.
Okay. All right. Are you going to keep moving it up though?
All right, can't do both. That's okay. All right, let's just take a break.
All right. Stretching break. Stretching break. Everybody stand up.
Yep. Everybody stretch.
Oh, yeah. Feels good to stretch. Stretching's important. It's good for your blood flow. Okay.
All right. Man, I'll tell you, this doesn't, I've been riveted. It doesn't feel like 3.5 hours so far.
I know. This sounds like bullshit. I never heard anything like this. Where'd you come up with that?
Yeah, where are you coming up with that?
I don't know.
I mean, let's give her a chance.
Yeah.
Maybe she's heard something.
Sources, please. Sources.
All right. While we wait, but neither of us are looking at the chat, so we're never gonna know because I'm moving and you're reading. So.
And eating a banana. Oh,
all right. I'm going to keep reading because this is my same section. So, all right. So, Dawn Perlmutter, who found 7 features of Norse pagan ritual. They include location. She explained that Norse pagans follow a Norse pantheon of gods like Thor and Odin. They have nature-based ideology where events and rituals are conducted outdoors in wooded areas and near water bodies. This murder occurred outdoors in a clearing and near a creek. Date. Norse pagan rituals often occur in on Norse holidays or events. The Nordic holiday, oh, Valisbolt. Valisbolt? I don't know, which honors Odin's son.
Valisblot.
Is he Vali or is that Odin's son, Vali?
Valisblot. I don't know. I mean,
Which
if
honors
Odin,
Odin's son, Vali, begins at sundown on February 13th and continues until February 14th. The girls went missing near sundown on February 13th and they were found the following day. Means used. Ritual killings often involve a knife or ceremonial knife. And here the girls were killed with a knife that made an unusual scalloped mark. Sticks. Ritualistic crimes usually involve symbolism at the scene, and with Norse pagan, the symbolism would include arranging natural objects in a specific way, like sticks and runes, and, quote, blooding the runes, close quote. These practices are integral to the magical thinking involved in Norse paganist rituals. Here, the stick arrangement shows intentional symbolism. It is difficult to explain the sticks as hiding the bodies. They're absolutely not working that way. They're not functioning that way. And that's a quote, I'm sure, from the excluded testimony that of this expert. The stick arrangement on Abbey mirrored the Norse rune Gebo.
Gebo. Gebo
right.
sounds good. Let's land on Gebo.
All right. And the intentionally placed stick formation on Libby looked like a Nordic bind rune. I was going to pull up a Nordic bind rune in the. Should we pause there for this? Anybody want to do that?
What?
You want to keep going? I want to do a Gebo rune and a Nordic bind rune. What do you think?
Negative. Let's keep moving.
Okay.
I mean, remember we had Dr. Perlmutter on. Like, everybody can watch that live. She was very informative.
I mean, but just look at this one. Wow. Looks just like that. I mean, any number of them could look like that. All right. Moving on. You're right. Let's stay on track. Allie gets sidetracked. That's what happens.
All right, I'm looking it up. Oh, so the Gebo rune looks like an X. That's exactly what it looks like right there. That's the Gebo.
Wait, did you share it? Because I'm not looking.
Oh, well, for the people can see
it.
it.
There you go. I see it. Okay.
Yeah. That's the Gebo. I'll see, like, bind runes.
They can look like numerous things.
Yeah, like I think.
Here, I got them up. I'll just click share this screen instead. Oh, I can't because this is sharing on my.
Oh yeah, there's a whole shit ton of them.
Yeah, I mean that could be a good luck one. It could also be the grace one.
These are all bind runes. It's a whole bunch of them. All the bind runes.
All look like little sticks and little formations.
Yeah.
All right. Thanks, babe.
Yeah.
Let
do it again.
All right. Manner of death. Ritual sacrifices often involve blood loss and torture. The girls' throats were cut and they suffered a prolonged blood loss, which is indicative of a sacrificial offering or initiation type activity. Body arrangement. In ritualistic sacrifice the sacrifice will be displayed or arranged at the scene in a manner that is significant to the group. And an upside down hanging body is an important element of Norse paganism because Odin hung from a tree for 9 days before discovering the runes. Like AW's positioning, the classic image of Odin depicts him with one leg bent behind the other.
That's unusual question, Gray Space. That's the $1 million question.
What? Because I'm not looking.
Where's Abby's blood?
Yeah.
Where is it all?
Yeah, it's a good question.
It's $1 million question.
Unusual blood pattern. Finally, a ritual sacrifice would involve an atypical or symbolic blood pattern. And here, the blood pattern on the F tree appeared to look like a Norse pagan rune.
Fehu.
Fehu. Okay. All right. So 6. This is all continuing under the caption of what the jury did not hear. The manner, thoroughness, and quality of the investigation. The jury never heard how law enforcement bungled the investigation into the ritual killing of suspects connected to Norse paganism. ISP disgraced Brad Holder, the father of AW's boyfriend.
I just want to say
disregarded. Sorry.
that bungled is a fabulous word
Yes.
and way, way underutilized.
Bungled.
I mean, it's very descriptive. Like,
It
you
is.
know, you think it's just a bungled, like just a bunch of moron Barney Fifes running around fucking shit up. That's bungling.
The jury never heard how law enforcement bungled the investigation into the ritual killing or suspects connected to Norse paganism. ISP disregarded Brad Holder, the father of Abby's boyfriend, and Holder's friend, Patrick Westfall, as promising alternate suspects because they lost evidence, mishandled interviews, and conducted a poor investigation. A. Investigation into ritual killing. After examining the scene, several officers believe the scene was too complex for just one person to be involved. When the BAU evaluated the murder scene, it found it noteworthy Abby was clothed, allowing Abby to dress ahead of time suggests the suspect felt differently towards her, including a possibly heightened level of guilt or regret, at least compared to Libby. Had we heard this before?
Well,
This might have been sealed or something. Let's see what the chat's saying, because this, Bob, we talked about this. I always said, and I think many people always said, like Abby seems like she was
not the target.
No, Abby's dressed, right?
Abby's dressed.
I thought that Abby that he had a special connection to Abby. And that maybe it really was about Abby. This might be suggesting the opposite, but that's what I thought. And then that's why he wanted to clothe her and showed regret and cleaned the blood off her hands. But I guess it could be seen the other way as well. But I don't know that we heard this before, that the FBI Behavioral Analysis Unit said.
Gray agrees with you.
What?
Gray agrees with you.
Yeah, it found noteworthy Abby was clothed, allowing Abby to dress ahead of time suggests the suspect felt differently towards her, including a possibly heightened level of guilt or regret, at least compared to Libby. Has anyone said if we've heard that BAU breakdown before?
I don't know.
It sounds new information to me.
Stephanie Rose says, I don't think we heard much about what the BAU said.
Okay. Law enforcement explored a group of pagans connected to Abby. In the weeks leading to the murders, Abby had been talking with a boy. LH. So that's okay. Abby had been talking with a boy, LH, and meeting up with him a few times. She kept this relationship secret from her family. On the day she was murdered, Abby invited LH to meet her on the trails.
Jesus.
LH had school, so he declined. While law enforcement was searching for the girls on February 14th, they learned about LH and AW's secret relationship, pulled LH out of class in Logansport, and searched his phone. That moment, LH texted his father, Brad Holder, "She's missing." Did you hear this before?
No.
What? This is insanity. This is just complete insanity. How's dad supposed to know who she is, by the way?
Right.
Why is dad the first one you text? He was supposed to be meeting LH, and he tells his dad. So his dad knew where she was going to be. Brad Holder knew where she was going to be. Did we know this before?
I did not know that.
Man, are you kidding me right now?
I never heard about that she's missing text.
But
I knew, obviously, I knew that Brad's son was dating Abby. I mean,
right, but not specifically that she invited him to meet her on the trails.
I
That
didn't.
he
I did
knew
not
she'd
know
be
that.
on the trails.
I did not know that.
This is shocking.
Yeah, sounds like a nexus.
It sounds like a fucking nexus.
The old
Is she
nexus.
kidding me right now? This is like mixed in the mix. I hope it becomes a large focus. Is this all new to all of you? Are you guys all freaking out there like we are?
Yeah,
This is mind-blowing.
that's what Spitfire said. Exactly.
Brad Holder knew. Okay, Brad Holder's son, let's just paint it in the light most favorable to the prosecution here, knew where Abby was going to be that day. He knew where her whereabouts, what she intended on doing that day. And can someone please, for the love of God, explain to me how he sends a text to his father, she's missing? How in the hell is he supposed to know who he's talking about? What kind of context is this? This is the context of someone who knows damn well what he's talking about.
Mm-hmm. Seems like there was a conversation that may have taken place at some point before that. Maybe where like he's saying, "Dad, can I take off school to meet Abby out there?" He's like, "Nah, you gotta go to school, man." I mean, there had to have been context prior to that, right? And you would assume if it was via text that they would have had that text as well. So
Well,
to me,
I
it seems
mean,
like it was
to me, it
impersonal.
screams dad knows damn well what he's talking about without any context.
Well, that's what I'm saying.
Because he had already told him where she was going to be.
Well, I'm saying from LH's perspective, he knows that his dad knows where she is because of an earlier conversation, is what I'm saying.
Right.
Which means obviously that Brad knows exactly where she's going to be that day.
Holy shit.
It's crazy.
Nexus much?
Nexus much.
I was this something that wait, I've got to change this to purple. Wait.
I mean, I am assuming that they verified if he was in fact at school that day, right? I mean,
well, they
right.
pulled him out of school. Oh, but not that same day, right? Ask. There goes my brain, Andy.
There goes my brain on drugs.
I mean, I'm assuming that is something that was just redacted. Like there was redacted stuff in the Franks memo, but why would that need to be redacted?
And
you didn't hear it in a hearing.
That's suspicious.
But it's on the record. It's in evidence because they couldn't be talking about it. Huh. Wow. It's crazy. All right. B, lost and missing interviews. On February 17th, 2017, law enforcement interviewed both LH and Holder. By then, law enforcement already suspected the murder scene involved a pagan ritual. During his interview, Holder reported being involved in a pagan tribe and spending every weekend in Delphi engaging in pagan rituals with Westfall and 5 or 6 others, including women. These rituals involved animal sacrifice, and human bloodletting. Holder admitted knowing about Abby and his son, but he denied ever meeting her. Law enforcement recorded Holder's interview, but the Delphi police recorded over their only copy before August 2017, permanently deleting it. Only a one-page narrative remains. According to that narrative,
I agree with you 100% on your police work there, Lil.
Did Mandy join the thing, or you're going crazy over there?
Oh, that's me. That's
Yeah.
me.
Okay.
That calls for some sound bites, all this shit.
Holder told police he owned a .40 caliber Smith & Wesson, but law enforcement never collected it, nor did they collect his cell phone. On February 19th, law enforcement interviewed Westfall. They failed to record his interview. Only a 5-paragraph narrative remains. According to his narrative, Westfall knew the woods where the girls were murdered very well. He reported knowing the girls, but denied ever meeting them. He also reported being a religious leader for local pagans, and he wore a necklace to the interview representing his efforts to pledge the Vinlanders, a pagan social club. There is no indication law enforcement asked Westfall whether he owned a .40 caliber firearm. Westfall's phone was not searched at that time. Alibi investigation. All right, let's hear it. Let's hear this great alibi that the state discovered that cleared these guys of everything. And this is something that if you are still paying attention and have been here from the beginning, Andy specifically mentioned. He talked about this. He talked about how they put it all together. They put it all together in this brief as to how it could have went down. So maybe that's what we're getting to. Alibi investigation. When asked for an alibi, Westfall claimed he was home with his minor son, and Holder told officers he was at work at Liberty Landfill. On April 13th, 2017, officers visited the landfill to investigate and spoke with an employee, Susan Case, who provided a printout showing Holder swiped out of work at 2:45 p.m., which was 30 minutes after the bridge guy video. Swiped. Okay. I don't know if it was like a sign out or a swipe out type of situation. Case invited the officers to review video to confirm the printout's accuracy, but they declined, nor did they interview other employees.
That's weird.
Wow. Unified Command marked Holder as a, quote, cleared suspect. Tipsters continued to identify Holder as bridge guy. Tipsters repeatedly called and reported Holder as a person of interest. One such one was Holder, quote, posts half-dead women and shows fascination with symbols out of tree branches. Another one says, check the father of one of the girls' boyfriend. His name is Brad Holder. He also fit somewhat the description. Each time a tip came in, law enforcement marked it cleared, nothing further, covered, or alibi confirmed. Sometime around March 2017, Detective Purdy interviewed Holder to get his assistance in connecting the murders to Norse paganism. Because Holder was not a suspect, Purdy did not record or document this interview with a report. Are you shitting me? Are you shitting me? Did you know that?
No, I did not.
So law enforcement is consulting with Brad Holder as an expert.
I mean,
they're getting his assistance in the case.
I mean, like he knows stuff about it. Like that sounds like pretty good police work.
I'm not sure that I agree with you 100% on your police work there, Lou.
Mm-hmm.
Oh man, we're getting to page 58 and I'm getting hungry.
Angry.
I don't really get hangry. I just get, I don't know.
Mm.
You get hangry.
Holy shit!
All right. So D, Unified Command declines to re-interview despite reports Holder is posting pictures of, quote, young girls believed to be deceased with sticks placed over their bodies. On April 12th, 2017, shortly before taking medical leave, Trooper Winters received a call from a tipster, Ryan Boucher, who shared pictures from Holder's social media. Winters found a concerning similarity between the murders and the pictures posted on Holder's social media. Those pictures depicted, quote, young girls believed to be deceased with sticks placed over their bodies. Winters also noted similarities between the stick formation on Abby and a bind rune Holder tattooed or drew on his hand. How the hell does Winters know what I never got an answer to this. How the hell did anybody no one knows a crime scene. They kept everything secret. They didn't tell people how they were killed. How does Winters know this similarity between a stick formation on Abby? How does he know anything about the stick formation on Abby?
Like Bobby Boucher? Like Bobby Boucher, the water boy. That was your Boucher correction.
Is it Boucher?
I mean, it could be. It's spelled the same way as Bobby Boucher, the water boy.
Okay.
I don't know the guy, so I mean, he could call it Boucher.
All right. So, Holder, quote, that's a bind rune on my hand. Basically, I took a Gibo rune and an Isa rune and made a bind rune.
So that's the one that looks like an asterisk, I thought. Like that is, I think that's the one that Holder has. Looks kind of like an asterisk.
Well, so do the sticks. Look kind of like an asterisk.
Mm-hmm.
Holder's social media also featured him holding guns and homemade knives. Winters immediately recommended to his superiors that law enforcement investigate Holder further, which they declined to do, claiming his alibi was cleared by the FBI.
Mm.
They don't even know who cleared the guy's freaking alibi.
Mm-hmm.
You know, those of you who did not watch the video to confirm that he's actually there and the one swiping out and whatever. Winters was not satisfied and urged the ISP to conduct its own investigation. No further action was taken. In 2018, Holder displayed a painting he made of Odin upside down with his right leg tucked behind his left, just like Abby's legs. Holder's painting also featured a red Fihu rune. Officers continued to find other social media postings from Holder that mimicked the crime scene, but law enforcement declined to interview Holder again. All right, E. Pagans finally re-evaluated. Once the state charged Allen, his defense team insisted that Holder and Westfall receive another look. Law enforcement re-examined Holder. He changed his story about knowing Abby back in 2017. He told law enforcement he never actually met Abby. But in August of 2023, he told law enforcement he met Abby once. And during his deposition in 2024, he said he met Abby twice. At least one of those encounters occurred shortly before Abby's murder at Westfall's home. At the insistence of Allen's counsel, law enforcement finally examined Westfall's alibi on August 17, 2023. Westfall's son, who was a minor when the murders occurred, could not remember if he was home with his dad when the girls went missing. This time, law enforcement collected Westfall's phone, but he deleted data before turning it over. On April 4th, 2024, Allen's counsel deposed Case, the Liberty Landfill HR officer. In February 2017, Liberty Landfill was operating two staggered overlapping shifts, one from 5 a.m. to 1:30 p.m. and a second from 7 a.m. to 3 p.m. On the day the girls went missing, Holder was scheduled to work from 5 a.m. to 1:30, but his badge swiped out during the second shift around 2:45. What in the hell? So he wasn't even scheduled. He was scheduled to be done at 1:30. He was scheduled to
Did
work.
they check to see if he got OT? Did he get OT? I mean, this whole part of it is insane, but there's also the concept that the state's timeline is bullshit. And that like the girls weren't killed. Like somebody else picked the girls up. He meets them. They do this deed later. I mean, it's like we can't pretend like the phone data doesn't exist with, something getting plugged into the phone.
Right, but
being unplugged from the phone at 10:30 at night. You
right,
know
but
what
for
I'm
the
saying? I
purposes
mean,
of No, I 100% agree. But for the purposes of the appeal and the theory that the state entered and their shitty investigation, this plays into that. Even though, right, I agree with what you're saying, but this just goes to show by their own theory, they didn't investigate viable leads.
Yeah.
Holder did not have sole custody of his badge. His badge was on a public rack outside the view of cameras and accessible to other employees, including second shift. There was no lock on the badges, and Holder's name was prominent on his badge. If somebody left when they were supposed to, but somebody else clocked that person out an hour or so later, would that be known? Answer, no. When the state, I would have also asked, can you just start working overtime for, like you're saying, was there overtime? Can you just work more? Is that like you can just do
work
that
an extra hour,
whenever you want?
15 minutes. Convenient. Has he ever worked overtime? Do you allow overtime? You got a second shift coming in. I don't understand. Like, is there overtime? Somebody not show up to work? There's a lot of questions. I'm sure they asked some questions.
I want to make this purple. We'll ask Andy about it later. Yeah. And then we'll just remember. Actually, I'll put a thing there because we won't remember. Asked about OT process.
Yeah, that sounds good.
Post. All right. When the state moved to exclude any reference to the state's investigation into third parties, the trial court held a hearing on the motion in July of 2024. At the hearing, Holder's wife testified that in 2018, Holder told her he had a fight with Westfall, quote, because Westfall wanted to up from animal slaughter to a different type of sacrifice. She also testified that Holder claimed that, quote, Westfall killed Abby, quote, with others, end quote, and that she needed to keep her mouth shut about it. And that, my friends, is the end of the statement of facts.
Holy shit!
And that's where we're going to end today. But let's
4 hours. 4 hours in.
There's not that many supers, so it won't take you too long to. I say you, but I'll hang.
All right, let's go through these soups. The Better Brock, remember, for 4 months. I heard about bad rulings in their Spencer case. Yes, there were some rulings came down yesterday.
We'll get to that in a different live.
Yeah,
yep,
different live, but yep, truth there. Charissa, and thank you for being a member for 4 months there. We appreciate that very, very, very much.
Yes, the Better Brock.
And Charissa, thank you, Bob and Allie, for covering and explaining this. Our pleasure.
And thank you for your continued support for 2 months.
Oh, and thank you for coming back and gifting 5 DD podcast memberships. We really, really appreciate that so much. IW 9338 with a $5 super. Thank you for the dono. We appreciate that so much. And then Mama X, how's Rick doing? I wrote to him, never received a response. Not that I expected one, but I stopped writing because he disappeared from the OKDOC roster. So I'm not certain he's receiving mail. That I would not know. I know that the appellate lawyers went down within the last month to visit him. So he's still there. Why he's disappeared from the roster, I have no idea.
Shit's
he's alive.
West.
He's alive. That's what I can tell you.
Oh,
Dr. Vonda. She's back. We love you. We love you, Dr. Vonda. Question: is the Cecil search source on in the record?
Yes, we talked about that. He Googled it.
It was a whole thing. That was
and I put it up when I saw her question and highlighted it.
Yeah, that was crazy. That was absolutely crazy. Thank you so much, Dr. Vonda. Precocent, Rosie's 1026 motion to recuse was struck from the CCS.
That's going back to my earlier question about, that was on the record. Why Why didn't they appeal that? Why didn't they appeal that portion of it or bring up the bias, one or the other? So
Yeah.
thanks for your continued support and for the
20
info.
members of Gloriousness. We love you. Jane, Angeline, family hug. Welcome to the fam. Love having you. Okay. Knee Kill New Elliott. Northeastern Kill New Elliott.
No, I think that's probably like
New
Nikill Lane,
Knee
Klein, Nikillen, whatever.
whatever. Love your work.
Sorry, by the way, that we're
Yeah,
butchering
we
your name.
butchered your name. So, but you just had an issue with Allen doing the crimes in 17 minutes, but you look at the Koberger case. I'm assuming that's supposed to be Koberger, and you completely agree that he could have done it in the same amount of time. Here's my thing with Koberger. He admitted it, and I believe him.
Right, but it was a question
in bed. Two of the girls were sleeping.
But it was a question early on in my mind, at least, for sure.
Sure.
Like, how in the hell did one guy do all of this?
Super tight.
So I understand your point. Point taken.
Definitely. Like, if you go back to when I first read their probable cause affidavit, I was like, that's tight. It's a tight time frame for one dude. But, you know, I mean, I have to accept him at his word. He pled out. I'm not buying the concept that he felt some kind of pressure or was some kind of move. You know, I mean, he was offered to have his life spared, and he bit. And he fessed it up.
Laxady, thank you for your continued support for 17 months. I'm not even in the US, and this case outrages me.
As it should.
Yes, we hear you.
Thank you.
Irish Mex.
Oh, family hug.
Thank you for becoming.
Welcome to the family.
Critical thinker. Bob Appellate Court filed request for docs. Normal?
Are you guys talking about the transcript? I saw that in chat.
I mean, it's unnormal that they're requesting some docs that they don't already have.
Especially but I don't even think they've peeked at this thing yet, which is strange, right?
Well, they could have noticed something was missing after they docketed it. Maybe.
Yeah.
I don't know. Your guess is as good as mine. We'll have to ask Michael, and we are going to start with Michael right here at the summary of the argument when we have our live with Michael.
Yeah, we have to let him decompress.
Well, plus we've been going at it for 4 hours.
No, I mean he texts me. It's good. It's good. He needs to decompress. Milliken man. So if I'm understanding correctly, the issue of where AW's blood was not actually addressed in the trial. No, not in the way that you would expect. Like, and that was, you know, Andy will be the first one to admit things that were missed on cross. You know, when they put their blood guy up there, you know, like, to me, that's always been a burning question. Like, where is all of Abby's blood? Where is all of it? You know, it's like, clearly there's the big spot, which was Libby's. So we know that she bled out there, but where is Abby's? I mean, in theory, could it have happened in the creek? Maybe. I don't know. I don't know. No, it was not addressed. Not in the way that you'd expect in a double homicide case. And thank you so much for your generosity, Milliken.
Yes.
Tracy.
And they weren't allowed to infer anything like, what are you know, so they had to walk a fine line. Like,
right. There was no, like, they couldn't even like breathe anything that was even remotely related to some kind of ritual or crime scene being unusual. So like them trying to get into those types of questions would have had, you know, the hair on the back of Gull's neck standing up on her perch, you know, like, dude, it's like they were shut down from all that. Like any kind of real inquiry into the crime scene was just not allowed. Thank you, Tracy, for gifting 1 DD podcast membership. We appreciate that so much. History and Homicide. Thank you both for powering through. Please like, share, and subscribe. Yes, listen to History and Homicide. Please like,
Yes.
share, and subscribe. We
We
appreciate it.
love when you donate to us to help us by telling others to subscribe. Don't forget to subscribe.
It's like one of our favorite things.
Yes, we are almost at 60.
The Milken Man says, wait, but Richard Allen admitted it 61 times, and that argument doesn't make sense. I like in terms of like this 61 time thing.
I don't count it. I
Well,
don't know what
but
61 times is ridiculous, but
all I can say is like what we heard at trial is what we heard at trial, and it was nowhere near 61 times. Sounds like there were 4 days in the 13 months he was there. Sounds like there were what 4 or 5 days where they were able to have him on a recording saying I did it, or evidently I did it, and then the mysterious Walla confession. That wasn't him actually speaking.
right. I mean, Koberger was coherent in a courtroom, not eating his feces and, thinking he was God in a prison cell.
Oh. You think Milliken's going back to Koberger? Maybe.
Yeah.
Because
Yeah. He said he confessed, so that's the end of it.
Well,
Koberger.
no, he pled guilty.
Right.
Which, I mean, that's you go to trial if you didn't do it, right?
Sarah, what does she get?
I mean, here's my counter to you. If Richard Allen did it and he confessed, why did he go to trial? Why did he just plead out?
Right.
Oh,
yeah. Sorry.
Sarah. Family hug.
Thank
See
you.
how Allie knows how important it is for me to give out the family hugs.
I do.
It's very important.
We appreciate you, Sarah. All right. So,
wow. Okay.
all right. My hands
there you go. What about
She's-
the new video evidence released to the public showing it wasn't Koberger's car? Again, love your work. Yeah. I mean,
don't know
no
anything
one's
about
ever
that.
convinced me on Koberger. I haven't seen it.
I haven't seen it either, so we can't comment.
All
right. Thank the people, babe. It's been a long 4 hours. Oh, we got a couple of Venmos. All right. Stand by, y'all.
Couple of Venmos. We gotta thank the peoples. Let's see. Leslie sent us $12 and said, thank you for always keeping us updated on the Delphi case and for sharing your legal experience or expertise and wisdom. Merry Christmas. Merry Christmas to you. And thank you so much. We really appreciate that. Let's see. There was another one here. Hold on. And then Kay sent $20 and she said, thanks, Allie. Feel better, Bob. Thank you so much, Kay.
Thank you.
And then I think there was one that came in late yesterday. No, I think I read this one. So, all right. That's amazing. Thank you guys so much for all of your incredible generosity. Thank you, more importantly, for your time. To all our mods, thank you so much for all that you do for the channel. We truly, truly appreciate you with all of our hearts. Keep Richard Allen in your mind. This case matters. Justice matters. Fair trials matter. Make it matter to you. We are going to continue this hopefully tomorrow. That's what the hope is. I still really want to do a something about the Rob Reiner, Nick Reiner homicide. So tragic, so awful.
We need more details, though.
Yeah, I mean, it's kind of like people like really kind of reaching, just trying to make content out of it. It kind of seems like, but what are you gonna do? Jeevy, thank you. Member for 8 months. Thank you.
Thanks for your continued support.
All
right, guys.
So keep your eye out for tomorrow. We're gonna try to coordinate with the Wizard of Habeas himself, Michael Osbrook. He'll be great to have on here to discuss the argument portion of the brief tomorrow. You guys make sure you take care of yourselves tonight because we love you so much. Because without you, I'd just be an old man
sitting around talking to his wife
and begging you to like, share, and subscribe and leave a comment on the replay crew. Bye.